Live-ish. How's everybody doing? Anticipating the hearing over at Alvin Bragg. He's not going to be there. It's going to be other witnesses. But we still want to see what's going on. Let's go ahead and check out who is going to be there. The Honorable Andrew Bailey, Attorney General, State of Missouri. Trainer, Commissioner, Federal Election Commission. Elizabeth Foley of Council, Baker Hostetler. And we actually have had an addition since last night. Norman Eisen, former U.S. Ambassador to the Czech Republic. Interesting. Not exactly sure where that's going. But we'll see. We'll see together. Any minute. We'll go ahead. Pin that. What's going on, everybody? So again, 4 witnesses today. 3 we knew last night that it would be the Attorney General for the State of Missouri, Commissioner for the Federal Election Commission, and then an attorney with Baker Hostetler. But since last night, in addition, a late addition, Norman Eisen, former U.S. Ambassador to the Czech Republic. What that has to do with the DA in Manhattan, I do not know. But we'll find out together. Let me make sure that everything's coming across the way it's supposed to be. It is. All right. All right. There we go. We're good. Just waiting on the Judiciary to start up. And let me just make sure they haven't started without us. A little sneaky, like the stream just got stuck or something. Well, let me go ahead and make sure. Nope. We're all here together, live. A lot of coffee this morning. 3 shots of espresso. Good morning, Cheryl. Good morning. Good morning to you. Waiting on the Judiciary. They're only a minute late. Well, that's okay. I'm gonna have to change out the Vivaldi soon. It works for everything, but it may drive me mad. So, I think what were the Hey, what's going on, Straw Hat Boy? Should be interesting. The witness list is interesting enough. We got Attorney General for the State of Missouri, a commissioner from the Federal Election Commission, an attorney with a Baker Hostetler, and former U.S. Ambassador to the Czech Republic. Late addition, that witness, the 4th one right there, wasn't listed last night. Baker Hostetler was at Bragg's old firm. I don't know why. I don't know. We'll find out together when the witnesses introduce themselves, I guess. It'll come out in the context. Scotland. Hello, Ernest. Hello from America. Or what's left of it. From the tattered ruins. I'm just kidding. I'm not in one of those major cities. Jim Jordan, usually very punctual. Let's see if the other... Nope, everybody is, you know, same place. It is live, but there's not a House Committee on the Judiciary. Their stream. The GOP's version of the stream also hasn't picked up yet. You know, I have a feeling that it did start and they just accidentally don't realize that they're not streaming. They've done this before. We know this move around here. So that's the guess. Matter of fact, let's go to Jim Jordan's Twitter feed. And see. Because he's usually pretty, he'll put, someone on his team will post the intro if we're missing it right now, which I think we are. I believe the dogs are going to go off. My dog, someone's at the door, so you know. So 19 minutes ago, Jim Jordan was tweeting. My guess is that the committee is underway, but that they're, whoever's in charge of pressing, you know, start broadcast or go live hasn't done it yet. Yeah, Jim's great. Jim's great. Cheryl, we love Jim on this channel, actually. There we go. Mugs available, Dave the Lawyer's store. Great Father's Day gift. Okay. If you could choose a superpower, what would you pick? Dr. Doom, interesting question. Are you still with us? I don't know. I feel like my kid asked me this the other day, too. Yeah, if I refresh the stream, nothing's happening still. Interesting. Okay. Still says we'll begin shortly. Bear with me, gang. I can't make them press the right thing to go live, which... So here's the guess, is that when they do actually go live, Jordan will have already spoken, and Nadler will be in the middle of speaking. Anybody want to take that action? If you haven't checked out, go check out Kennedy Grillin' Judge's Supercut. It's my most ambitious video. I'm going to do a few of those, I think. I'm going to do like a Hawley version, a Mike Lee version. Who else? Marsha Blackburn. Is it Marsha? Martha? So who's at the hearing? This is the Judiciary. So Hagman. Let's see. She is not on Twitter right now. Maybe these people have two Twitter accounts usually, like their campaign account. Yeah, she's more active on her official account. Harriet Hageman. We love her on this channel. Jeremy DeWitt. I don't think I've followed it. Mark M. Oh, no, I've, okay. Yeah. He's the guy that does the funeral processions, right? I believe. I think. Foley would be a great VP. I just, look, when I'm certain about these things, I'm usually wrong. I don't think it's going to be someone from the Senate because the Senate is, they want to keep the Senate. They don't even have the Senate right now. Republicans don't have a majority in the Senate. It's a thin, right? So a lot of these are 2 Democrats. I think they're actually caucus as independents, maybe more. I don't know. I like to fall back on Dunbar's number a lot on this channel, saying that I can only keep just 500 of these fools. I can only keep track of about 125 of them. This is a little later than they usually are. Who on committee can we check their Twitter feed and see, hey, what the heck is going on here? Who's the ranking member? It's Nadler. I don't think Nadler's going to be active on Twitter, but I could be wrong. Maybe his staff is pushing him. This is like pushing him right along. No. Yeah, it's not as... No. Nothing. All right. What could we watch together? They are 10 minutes late. We are on time. We were on time, chat. Let's see. We were on time. Is there news about Hunter? Well, let's see. Let's follow up on the DeWitt. Plea deal is 9 years. He has until today to accept it. That guy's crazy. Life of chaos. Front page of the New York Post. Hunter Biden kept drug gear at Joe's VA home, of course, and slept with members of Amoeba Group. Don't know what that means. You ever read headlines and they just barely make sense to you? Barely. And then that's, let's see, Chow down. Biden still thinks it's D-Day as he awkwardly salutes Italian Prime Minister. Saw this one at G7 summit arrival. Oh, no. Yeah. Right. Yeah, Hawley would be great up there. Any one of those positions. I don't know. He scares me sometimes because he's like, he's almost too good, right? Too pure, too white knightish. No, I'm just kidding. Attorney General. Yeah. See, that's he would make a great Attorney General because his policy is not to raid people with long guns and ballistic shields, or at least that's what he's more or less indicated in committee meetings. So, let's see if there's another meeting underway that's interesting that we can maybe just peek in on until this one actually figures out they're not live. Let's see. This is the good one. This is the one I want to listen to. Semi-annual report on Bureau of Consumer Financial Protection. Maybe a call to action meeting the needs of spinal cord injury and disorders in the veteran community. Markup Committee on Science, Space, and Technology. I mean, that's at 11. We're at the 10 o'clock spot. All right, let's check out the Senate side. They have closed business meeting for the armed services. Energy and Natural Resources has an oversight hearing to examine the Bureau of Land Management. Maybe. Yeah, actually, that's underway. That started at 9:30. So, Finance has a business meeting to consider the nominations of a bunch of people to a bunch of different positions. Appropriations just started 13 minutes ago. Hearings to examine proposed budget estimates and justification for fiscal year 2025 for the Securities and Exchange Commission and the Commodity Futures Trading Commission. It's going to be all buddy in there, you know. They're going to be all, hey, you're not going to look over here while we insider trade. And then they're like, yeah, you're going to approve our budget, right? Let's go peek. Maybe. And the Judiciary. Oh, that could be good. Senate Judiciary. Let's check them out, huh? Oh. Listen, I'm not crazy. This is still not going. It looks like maybe they're okay. I think maybe we're
tends
live
to carry out their obligations, quickly discovers that managing anything like a 500 or 600 caseload is not manageable. This isn't a red state issue or a blue state issue. It's an access to justice issue. The Judges Act, as you mentioned, Mr. Chairman, will bolster our federal judiciary by creating 66 new judges across 25 districts across 13 states. These selections were in no way political or random. They were based on the recommendations of the Judicial Conference led by Chief Justice Roberts and 25 other federal judges. They determined these districts. This manager's amendment would break it from 3 tranches into 6 across 3 different administrations across a dozen years. I want to thank Senators Young, Padilla, Hirono, Cruz, Tillis, Lujan, and Lankford for their original and bipartisan co-sponsorship. Mr. Chairman, I want to thank you and Ranking Member Graham and your staff for working closely with us to improve this bill. Your changes have made this bill stronger, and this is what legislating is about, finding places to work together for the greater good of our nation. We can do something today that hasn't been done in a generation and give our federal courts the resources they need to effectively deliver justice to our public. I hope everyone will support this bill today and that we can swiftly move it through the Senate and the House
Matt, you're going to have to explain the Nancy Mace.
Before I recognize several of your colleagues who seek recognition, do you want to offer the manager's amendment?
I move the adoption of the manager's amendment.
All those
I'd like to be added as a co-sponsor.
Thank you, Senator Graham.
All those in favor of the manager's amendment say aye.
Aye.
Opposed, no. The manager's amendment is adopted. We have recognition sought by Senator Whitehouse and Senator Blumenthal.
So Hawley's in there right now.
I'll go back and forth. Senator Grassley and Cornyn as well.
Again, this is not.
Thank you, Chairman. I'm going to support this bill. I like Chris and Todd. I admire the work that they have done to move this forward. But before I can support it on the floor, I want to hear from my friends from Texas a little bit of an explanation of why it is that Texas needs additional judge slots, while 5 vacancies have been kept open in Texas. So I'm for this, but on the theory that if it's really that urgent, why are there so many vacancies? That's a conversation I think we should have before the bill comes to the floor. So heads up to my friend John Cornyn.
Senator Grassley.
I think most of the members of this committee probably don't know of my opposition to asking or giving more judges, but I'm going to vote for this bill. But before I give you my explanation of voting for it, I just think all of you should know why I've been standing in the way of some of these permanent positions. I haven't stood in the way too much of temporary judges, but I've had questions about how the Judicial Conference allotment works out and haven't been satisfied. I think this bill will help us in that direction. I haven't been satisfied that every senior judge is working hard, and if they aren't doing a certain amount of work, then we're expending a lot of money on staff that they have and clerks that they have. What I have studied about the 93 or 92 district judges, or their, I should say their districts. Some of them are not working very hard, and others are way overloaded.
I see.
With
it was a compliment. I didn't understand
with the work that
that,
they
Matt.
have to do in the number of cases. And I thought there ought to be some way that we could, by moving judges either permanently or on a temporary basis from some district to another district to help that out, would be a partial solution to the problem. And then, of course, we always put in temporary judges. But after the years of having these concerns about
Thanks, Chris.
whether we ought to put on more judges or not, I still gotta say that the people of this country are entitled to justice, and justice is a speedy process, and when that's slowed down, it's not really justice. So those are the concerns that I've had until now, and I suppose I still have some of those concerns, but I think this bill will help with some of these concerns. First, I'd like to note for the record that even with changes, I still think this bill creates too many new judgeships. So many, in fact, that it'll end up being the largest omni-judge bill at the district level in more than 45 years if it becomes law. Nevertheless, my office has diligently worked with many of your offices in an attempt to improve this bill, something I think that we've achieved. So if you want to know why I've changed my mind on it, it's because of the collegiality of people on this committee that was really willing to look for some changes in the bill. With these changes, this bill will now more thoughtfully and deliberately create new judgeships incrementally in 6 tranches spread out over 12 years. Given the large amount of judges, this is much more reasonable and manageable pace for our judiciary. This bill will now also improve transparency by evaluating judicial caseloads and the method by which future judgeship recommendations are offered. This is achieved in part by having the administrative office of the courts post the biennial judgeship recommendation reports online where it can be assessed by the public. This bill will also direct the Government Accountability Office to evaluate factors that may impact judicial caseloads and future judgeship recommendations. In particular, the GAO will look at judgeship methodology for the first time in over a decade, as well as the impact of the non-case time on overall judicial caseloads and the utilization of senior judges within our courts. I'm hopeful that these efforts will ensure that judicial administration is efficient and effective. Additionally, these measures will help dispel some of the intrigue underlying these judgeship recommendations in the future. While this bill isn't perfect and it does not have everything that I would have wanted, it is a much improved bill. Given these changes and the good faith effort of our colleagues, I'm, as I've said twice already, on vote for this bill. Before I yield back, I'd like to thank, in particular, Senator Young and Ranking Member Graham and their staff's hard work on this bill. I'd also like to thank Chairman Durbin and Senator Coons and their teams for their work on this bill.
Harry, could you
Thanks, Senator Grassley. Senator Blumenthal.
Thank you very much, Mr. Chairman. I want to join in thanking Senators Coons and Young and all of our colleagues. I asked to be added as a co-sponsor, if there's no objection, Mr. Chairman. And
without objection.
I want to point out some practical considerations here for all of us who have litigated in federal court. We have been frustrated on more than one occasion by delays. I can remember waiting literally years for a decision from a district court judge, and there is nothing anyone can do, literally anyone can do, other than seeking mandamus from the Circuit Court of Appeals, which is, I think, close to a death sentence for any litigator in terms of what the reaction of the district judge will be. So we have to recognize that there are delays, that they are frustrating, and they are costly. This is not about giving judges a break or creating a bigger bureaucracy. It is about achieving swifter, more expeditious justice. And the numbers of cases have risen, but the numbers of judges have not. And that is a recipe for unfairness and injustice in our system and costs to the litigants, whether they are companies or individuals who are simply seeking a decision. And often the lack of a decision itself may be costly to one side or another. And I just want to point out one last fact here. We had a very, I think, interesting back and forth yesterday, Mr. Chairman, on the proposal for a judicial code of ethics for the United States Supreme Court. There was a lot of talk about the independence of the judiciary. This kind of measure, coming from Congress, obviously sets resources for the judiciary. That's our proper role. And we also have a responsibility for accountability in some measure when we create those judgeships, which is why we have the Judicial Conference, which we have also created. And they have a rule of a judicial code of conduct for the judiciary, that is all judges except for the United States Supreme Court. So I think we're fulfilling our responsibility here to an independent judiciary by giving them the resources they need to do the job. Thanks.
I think they haven't clicked start yet.
Senator Cornyn?
Thank you, Mr. Chairman. Let me start by addressing Senator Whitehouse's question. Why does Texas need more judges when there are vacancies currently existing? Just like to remind everybody, Chairman, you know this very well because you've actually complimented Senator Cruz and I on our Federal Judicial Evaluation Committee for filling 3 district judgeships and the Fifth Circuit on a cooperative basis with the
Senator Cornyn, it was a weak moment.
It was. Well, I didn't know how long it would last.
See if either one of them.
It was effervescent, I guess.
He's got to go up and
you'd have
flick
to
a
say.
quirk.
But we've also interviewed people for the McAllen vacancy, but been able to not yet achieve consensus with the White House. The point is, we've been doing it in a cooperative, bipartisan way. We happen to be a big state with a number of vacancies. We're going to continue to work in good faith with the administration and this committee to try to fill these vacancies. I don't think that's not controversial in my view. So I too want to thank Senator Coons and Senator Young for their leadership on this. I know Senator Cruz has been involved in this legislation as well. We're dealing with a large number of cases, and guess what? A lot of these are immigration cases along the border due to the unprecedented influx of migrants across the border and cases that need to be litigated by the border courts. I'm going to, like Senator Grassley, support this bill with some caveats. My support's based on the understanding that vacancies on Texas courts will be continued to be filled by Texas senators working with the White House to nominate qualified individuals. What I'm alluding to, of course, is the blue slip, which ensures we get the very best and the brightest. And Senator Cruz and I work hard to advise and consent on Texas nominations. We do that whether there's a Republican or a Democrat in the White House. We're proud of the judges that we have recommended through this process, and we'll continue to do that, as I said. Some have called on Senator Durbin to eliminate the blue slip, which would be a huge mistake. If you learn one thing after serving in the Senate for a while, it's what goes around comes around. And frequently you rue the day that you begin to cut corners and break the rules. The blue slip is an important institution, and I do appreciate Mr. Chairman, your willingness to stand strong on preserving the blue slip, again, based on the understanding that we're going to work with you and the White House and on a bipartisan basis to fill these vacancies in an orderly and in an orderly basis in a deliberative fashion. So my support today for this bill is based on the understanding the blue slip will continue to be the tradition of this body. It's also based on the understanding that the Judicial Conference will stay in its lane. And what I mean by that the Judicial Conference doesn't have the authority to legislate. Recently, the Judicial Conference stopped short of issuing mandatory policy that would change how Texas courts assign their cases. They did this after getting a letter from the Majority Leader who's taken a recent interest in how Texas courts function. Majority Leader thinks he knows what is best for Texas courts and how they manage their dockets, and he believes he should be the one to determine how they should assign cases. The letter he sent to the Judicial Conference to that end, in response to that letter, the Judicial Conference convened a committee and issued a proposal that, of course, was not binding, was merely guidance, but it embraced the Majority Leader's preferred scheme for assigning cases. Of course, the Judicial Conference glossed over the fact that Congress writes the law, not them, and that the current law gives the judges in those respective districts the authority to assign cases as they see fit. It's come to my attention that the Judicial Conference is at it again, and so I have serious concern about whether they will continue to engage in an attempt to legislate and usurp the prerogatives of the Congress. Decisions on how cases are assigned are vested with Texas judges, and the current proposal today was done in consultation with the Judicial Conference,
supposed to be a hearing on Bragg
which
right
is what
now.
they want, more judges.
Morning,
and I
Donald.
agree that this is a necessary and laudable goal, and I'm prepared to support this goal at this juncture. But if they continue to legislate through their shadow committees, then I am going to have issues with this bill and others that they may want
Thursday,
moving
10
forward.
a.m.
Thank you very
Eastern
much.
Time.
I might note for the record the Judicial Conference is chaired by the Chief Justice, John Roberts. So
what?
Sliding into the
You're arguing that he has a political agenda that you disagree with?
No, Democrats have a political agenda by trying to force a code of ethics on an independent branch of government, the Judiciary. So I understand that political agenda, but we're going to fight that one, and we'll fight the agenda of the Majority Leader in trying to dictate how Texas courts assign cases.
Establishing an enforceable code of ethics for the highest court of the land, I don't believe is a partisan matter. It affects justices appointed by Democrats as well as Republicans.
I disagree,
Are there any
Mr.
other
Chairman.
comments or amendments to the pending legislation?
Mr. Chairman,
Senator Graham.
the discussion of this bipartisan bill has been very interesting. So, in 1990, the number one movie was Home Alone. In 1990, the number one song was Hold On by Wilson and Phillips. That's the last time we've actually had new judges. So, to all the members of this committee, thank you for having input. Senator Cornyn, Senator Cruz, thank you very much for being able.
Is there a chance Senator Graham's going to sing a few bars?
Freezing in hell is a better chance. So,
Senator Graham, I just want to correct you, sir. You were one of the hippest, coolest senators there is, but it's Wilson Phillips, not Wilson and Phillips.
okay, there you go.
Okay.
Thank you. To those people, I hope you still get residuals. So the bottom line is I've never seen the committee work together more collaboratively. And to Senator Young and Coons, I thought this thing was going nowhere. And you've worked with Representative Grassley. You've been very strong in your opinion, but very reasonable in trying to get to yes. I just think we need more judges. It's been since 1990. We didn't pull these numbers out of a hat. Somebody thought about it. Kind of makes sense. And I share Senator Cornyn's concerns. But 1990's been a long time. There are a lot more people today than there were in 1990, and I'm glad we're making progress.
If there are no further amendments to come before
Keep
the
moving
committee,
down the Twitter DM
the clerk will
chain.
call the roll
It
on
could
S
be that
4199.
they delayed this thing, or I just think they probably haven't started streaming because they've done that before.
Aye.
Aye.
Ms. Verono.
Aye by proxy.
Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Welch. Ms. Butler.
See no indication. Go ahead.
Mr. Graham.
Aye.
Mr. Grassley.
All right.
Mr. Cornyn.
I'm starting to feel silly sliding into everybody's DMs. Like, is there a chance that it's just not happening? Usually they'll tell you
I have a
on
proxy.
on the websites there.
Mr. Cotton.
I should
I have
probably
a proxy.
Mr. Kennedy.
I have a proxy.
6/13/2024, 10 a.m. Rayburn
I have a proxy.
House Office Building.
Blackburn.
I have a proxy.
Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 20.
The bill will be favorably reported to the floor, and for the record, I'll repeat that Senator Butler is absent because of COVID. We understand that
How is
situation.
yeah.
If there's no further business to come before the Senate
Senator Butler,
Judiciary Committee,
shame
it
on
stands
you.
adjourned.
Oh no. Didn't even hear from Hawley. He's out already. Onward to the next hearing. Really? Do you think they're doing this on purpose, maybe? Could be. Could be. Who did we say what is going to be an interesting hearing? Securities and Exchange on appropriations. Let's check them out.
This type of data availability, what's being done to protect it. You mentioned at any time you've got 1,500 to 2,000 investigations underway, presumably relying on this data. What are you doing to protect it, and what law requires you to protect it and to penalize anybody that might disclose it?
It's a very important matter to us. First, only a limited number of people at the SEC even have access to look at.
Can you give us the numbers, Mr. Chair, to give a sense for that?
It's less than 3 or 4% of the agency. We can come back to you and give you, but it's in that 100 to 200 range. So it's not even the whole 1,300 people in enforcement, to give you a sense. It's a much narrower group of people, and that's a really, they all go through particular training and so forth of how to access it.
How did they get permission to access it?
With respect, so we have 7 minutes allocated for colleagues. We're about a minute 45 seconds over here in terms of exchange. If you wouldn't mind just a quick answer, because I just want to make sure we get to other members. I don't know if, and we're going to have another round. Okay. I have 7 minutes so people could have plenty of time. Now we're. Okay.
And I'm also willing, Senator, to meet with you later today or tomorrow, or to get on the phone and chat this through with you, or any other matter with you.
No,
we can come back to it on the second round too. I just want to make sure. So let me pick up, if I could, Chairman Gensler. Senator Hagerty raised the issue of crypto assets, cryptocurrency. Obviously, this is an area where Chairman Benham has been involved as well, and we all are very aware of the fact that there's a big debate going on Capitol Hill right now regarding whether these things are fish or fowl and which agency should have jurisdiction. But I would hope that we would all be able to agree on a couple things, which is that we want to protect consumers and the public, number one. And number two, however we move forward, we deal with the anti-money laundering equivalent part of this, making sure that these assets cannot be used for nefarious purposes. So again, our House subcommittee counterpart included a provision, Chairman Gensler, regarding SEC crypto regulation, and specifically it reads, none of the funds made available by this act may be used to carry out an enforcement action related to a digital asset transaction, except for enforcement actions related to fraud or market manipulation, unless, and it goes out and sets out some conditions. Could you speak to what the consequences would be with respect to the goal of protecting consumers and the public if this were adopted?
It would be seriously undercut our efforts. While not all crypto or crypto securities, some are under Chair Benham's jurisdiction. Those that are have an obligation to disclose to the public. It's called a registration, to disclose to the public full, fair, and complete information. We'd lose that. Secondly, intermediaries, so-called exchanges, broker-dealers, and the like, register, and then the public gets protection. For instance, a really key protection is that your funds are segregated and protected. And so our securities laws are not solely about fraud and manipulation. Stamping out fraud and manipulation is really important, but it's also about if you register, in this case, a crypto security token, you have to then give disclosure so the investing public gets the benefit of that. If you register a crypto broker or crypto exchange, you get the benefit of things like segregation. You get the benefit of a rule book on the exchange, like we have on, let's say, the New York Stock Exchange. There's a lot of benefits. But it would also undercut ongoing current cases that we have in front of
the Republican
courts
National
right
Lawyers
now.
Association.
And we've been very successful in a number of these cases where, at least on the law, on motions to dismiss and so forth, the judges have found we've got the appropriate reading of the law, and then they'll move on to the fact part of the cases.
So just to be clear on that last point, this would interfere directly in ongoing cases.
It would interfere directly on ongoing cases that we have in front of various various district courts.
Thank you. So, Chairman Benham, I mentioned the importance of making sure that these assets, currencies, cannot be used for nefarious purposes, and the need to apply the equivalent of the anti-money laundering standards to these
suppressed
assets, regardless of how we decide to treat them. Would you agree with that? And what measures should we use? Should we just simply apply existing AML provisions to these currencies?
Senator, thanks for the question. You know, from a CFTC perspective, and as I've said publicly for many years now, it's a legal authority issue. We, to Chair Gensler's point in the earlier question, have anti-fraud and anti-manipulation authority for digital commodity assets. So we've been quite successful over the past 10 years, really, in bringing enforcement cases. But the weakness that we have, or the shortcoming, is that we have to rely on folks coming to us, providing tips and complaints. We don't have those traditional regulatory tools, registration, custody, surveillance, oversight that have really made American capital markets and derivatives markets so strong. As it relates to AML KYC, again, it's a legal authority issue. If Congress were to move on some authority for the CFTC, certainly that would be a key component of this, given what we've seen and experienced in this digital asset space around AML and KYC. I don't think we need to stray too far from existing law. A lot of AML, KYC enforcement.
Americans who are food insecure. So what we need to understand is that 4 out of 5 SNAP households include a child, an elderly individual, or a person with a disability.
This is not it.
I know, because particularly
well, I'm at a loss. I don't know what to do. I was all dressed up and nowhere to go. I mean, they're going to start this thing, but maybe it's an hour late. Is that what's going on? Oh, you can't hear me? Can you hear me now? Me? Is it you couldn't hear me over them talking? Let's find out. Yeah. I think that's what you guys meant. Yeah. I hear me. I don't know. Whose side are you on? I don't know. I'm on the people's side. It seems to be us versus the political elites. The Bidens, the Clintons, the Pelosi's. God. Hunter Biden. Facing 25 years. What do you think? What do you think Hunter gets? Yeah, I'm sorry. Yeah, you couldn't hear me over them. I know. And I know better than to talk over them. But I'm trying to express that I'm looking, so there's no indication on what is going on with this hearing, which is annoying. If I go to the Judiciary, they all have their own, the House, Judiciary, GOP has their own Twitter, and then, the Dems have their version of it, and neither have tweeted about this. Nothing. And if I go to the website itself, everything looks like it's supposed to be on time and going, but it's 10 a.m. Eastern time and nothing's happening. Manufactured felonies. It was like this when I found it. Yeah, 34 more times the votes, yeah. Unreal. And that's all they're going to say. You're in a cult, 34 felonies. Duh. No. It's the biggest projection I'd ever seen. Honestly. It's like you're worshiping a half-dead guy. Still wearing their masks. It's like they're wearing their, it's like the yarmulkes on their mouths only, It's a religion. It's a cult. They're injections. They're injecting the Kool-Aid. That's what they're doing. They've begun inject, and then they're pointing to everybody else saying we're in a cult. It's sad. If you haven't already, got the Kennedy. Why not watch my video?
It's one that the district
on Senator Kennedy grilling judicial nominees.
Mr. Chairman, my name was invoked.
I noticed.
As
So
a
this
proud
is on my
Democrat,
channel
we would
right now.
like
My
that part
name
of your
was
history.
invoked, Mr. Chairman. Now, I just want to let the record reflect, and I love Senator Whitehouse. But I'll tell you one thing, I've never been a Marxist. I've never been a Marxist. And I've never admitted I was a Marxist and then not turned the document over to this committee. We had to find it. And we did. And now the testimony under oath today is, I didn't say that. The reporter said that. No, the witness said that. And then the testimony is, well, I didn't mean it to become public. That's not the issue. So, if we won't get personal here, we can.
Senator Graham?
Kennedy.
Thank you. Let's agree on the following. A Louisiana Democrat's probably not a Marxist.
Thank you, Mr. Chairman. The White House counsel's office, as we all know, is the part of the White House that is charged with advancing a president's nominees to the federal judiciary. Every president in recent memory has had a White House counsel's office. And all White House counsel offices do their job. They try to, they think they're right, and they try to get what their boss wants. And of course,
so this actually,
all senators think they're right.
I should change the title here.
We try to get what we want. It took, I think this is true of all White House counsel offices. It took a while for President Biden's White House counsel's office and I to get to know each other. But But we have. Now, I'm not suggesting that we are ready to go to summer camp together, and it could all fall apart tomorrow. But we have had a number of vacancies on the federal judiciary in Louisiana. We need to fill them. Working with White House counsel's office and my quarterback, Senator Cassidy, we filled 2 of them. Today,
sorry, guys.
We have 2 additional splendid nominees to offer up to you. I returned a blue slip on both of them.
I keep doing it.
And unless they really, really, really screw up today, which I do not think they will, I'm going to vote for them. Senator Cassidy covered Jerry's and Brandon's resumes. Look, I'm not going to repeat everything, but if you look at these 2 gentlemen and aren't impressed, as Lindsey Graham says, you shouldn't be driving. Mr. Edwards graduated from Georgia State University, Vermont Law School. He's clerked for 2 district court judges in Louisiana, 1 Republican, 1 Democrat. He spent 13 years at Blanchard Walker, a hell of a law firm. He was a partner there. He's been the chief of the civil division in the U.S. Attorney's Office in the Western District. He's been rated unanimously well qualified by the ABA. Brandon Long, Mr. Long, is he's from New Orleans, actually Metairie. He went to the University of Texas. He graduated cum laude from Duke Law School. Spent 5 years at King and Spalding. Was earning a great living. Decided to get into government service. We appreciate that. He's been a federal criminal prosecutor in both D.C.
probably take over
and the Eastern District of Louisiana. He's tried 32 cases to verdict. I think Mr. Edwards has tried a bunch of cases to verdict as well. He was FBI Director Ray's Deputy Chief of Staff for a while. And he's eminently qualified. I've gotten to know
if you don't like
both of these gentlemen.
Senator Kennedy, you're
each
not
of
American.
them is smart. Each of them is principled. Each of them has thought about the world, and they've formed opinions about the world. But I am convinced that they will limit their decisions to the law and to the facts of a specific case. Each understands the role of our Madisonian system of checks and balances and separation of powers, and each of them understands the importance and the nuances and the limitations of the law. And I'm really glad we could get this all worked out. And my work here is done. That Senator Booker has a silver tongue, doesn't he? He's good. I know Mr. Long and I know Mr. Edwards. I don't know Mr. Hodgie or Judge Maddox. Congratulations to all 4 of you, though. Judge Maddox, I think I'll start with you. I just want to talk about the law a little bit. I stipulate that you will follow the law and apply it to the facts of the case as you are guided, including but not limited to precedent. I thought the Supreme Court just handed down some really interesting decisions. One of them has not been talked about much, but I found it fascinating. Tell me about Moore v. Harper. That was the independent state legislature theory. What's that all about?
Good morning, Senator.
Good morning.
Yes, Moore v. Harper concerned whether or not the Elections Clause in Article 1 of the Constitution gave the state legislature sole authority to regulate elections for federal office in their states without any judicial oversight. Mm-hmm. And the Supreme Court held that the Elections Clause did not preclude judicial oversight of the legislature's regulation of federal elections.
I can tell you looked at the case. Here's one way of looking at it. every state has a state constitution. And I want you to tell me if you think I'm wrong here. Every state has a state constitution. And in fact, many state constitutions preceded the federal constitution. And some of the provisions in our federal constitution were copied directly from state constitutions.
We're waiting until they start. I'm guessing they're an hour late at this point.
What the Supreme Court is saying to a state legislature is, look, yes, Congress gave you the power to draw congressional districts.
I could be wrong.
But you've got to do it consistent with your state constitution.
So right now we're just watching a video I released this morning on my channel.
So the state courts get to weigh in.
Kennedy grilling judges.
And if the state courts don't render opinions that are consistent with the federal constitution, then the federal courts get to weigh in. What do you think?
I believe that that's a fair reading of, or maybe perhaps reading between the lines of that opinion. That particular question is not one that I'd considered previously, although I have reviewed that opinion.
That's this video.
Yeah. I just found the whole case very interesting because the theory of the plaintiffs was that state legislatures can do anything they want to do with respect to congressional reapportionment because Congress gave them power. But it ignored the role of the federal judiciary and the state constitutions, which, anyway. Mr. Haji, tell me about, I need to get a life, I guess. Mr. Haji, tell me about this Waters of the United States controversy. What's it all really about?
Senator,
anyone looking? By the way,
I've been an attorney for 12 years with the Navy, and I've practiced in government contract law
mugs
for a
available
long
at
time,
Dave
and
Lawyer
I've
Father's Day.
Worked on those kinds of issues for the last almost 12 years. I haven't encountered that particular issue that you're referencing.
Okay. All right.
Look at that
tell me,
contemplation.
this will be my last question. Tell me, doesn't strict liability seem inherently unfair to you?
So my understanding of strict liability, Senator, is that there's limited circumstances for when it's applied, and my
like
job.
What? Like what?
Excuse me?
Give me some examples.
Like in product liability case, for example. And I think the idea of strict liability is under those limited circumstances.
Where's the DWS?
To encourage the right
Not
sort
a bad
of
idea.
behavior for, let's say, a product manufacturer.
I have to be careful about likenesses, right? So no Jack Smith mug, but I can have a Tears of Special Counsel mug is available.
Well, I'm not saying I disagree with you, but tell me, how does it comport with due process? I mean, this is basically, some would argue, this is basically a legislature saying, hey, if you do it, you're automatically liable. You don't get due process. You don't get to defend yourself. There are no defenses. What do you think about that?
Yeah.
Well, my understanding is that strict liability.
My number one drug of choice is caffeine, and that's true for a lot of attorneys. And most, a lot of people around the world. So hey, yeah, I'm
branches of government from that
I'm like
because it, like you said, takes Congress's perspective.
For marijuana, they sell bongs, right? This is the equivalent of that. I'm hawking
Thank you,
mugs.
Mr. Chairman. Congratulations to all of the nominees. Judge Mahalchek, you remember a case called Yentzer v. Potter County?
I have a recollection that I presided over that case. I don't know if I recall the details of it.
Okay, and you were reversed, is that right?
We're going to give
I
it a
believe
couple
that
minutes.
was a case that I issued. I was a magistrate judge in that role and in the referral role on it, and it was reviewed by the district court, yes.
And you were reversed, right?
Late. They're going to start
I don't
soon.
recall in that case if the
report
report and the recommendation was adopted in full or not adopted in full. But yes.
The higher court said you incorrectly analyzed qualified immunity and you incorrectly cited the 11th Amendment. Do you remember a case called Myers v. Clinton County Correctional Facility?
I recall that case as well.
And you were reversed in that case too,
For
weren't you?
Loco?
I believe it was adopted in part, yes.
Do you remember a case called Dennis v. Sheridan?
Yes, I believe I recall that case as well.
And you were reversed in that case too?
I believe that R&R was not adopted in full, correct? Yes.
Okay, but you were reversed.
It was not adopted, yes,
Is that
by
the
the
same
district
thing
court.
as being reversed?
It's a different, the district court declined to adopt the report and
The higher
recommendation
court
in
said
full.
you were wrong.
The district court disagreed with my report, yes.
Yeah, okay. Do you remember a case called Shania v. East Pennsboro?
Yeah, the Shanias are pro se plaintiffs who have brought a number of cases, so I'm not sure which one you're referring to, but yes.
I'm just curious, you were reversed in that case too, were you not?
In part, yes.
Okay. Do you remember a case called Spanier v. Libby?
Yes, I do.
The president of Pennsylvania State University was convicted of covering up child sex abuse crimes.
Oh, boy.
And you let him go on a habeas corpus petition. And the Third Circuit reversed you, is that right?
I directed that a new trial should be held with a different jury instruction, and the Third Circuit disagreed and found that he had received the due process he was entitled to, yes.
Hold on, let me see.
Well, the Third Circuit said you failed to cite, analyze, or properly apply.
Do you hear that? Are they starting the Bragg hearing, maybe? So let's see. I think that's what's going on. Let's get through all
Is conducted through the
An hour late. How dare they change the schedule on us and not let us know? Do they know who I am? Nobody. So let's go ahead. It sounds like they're ready and they're starting.
Mr. Eisen?
Yeah, I hear Jim Jordan going. Let me go ahead and change the name of the...
Mr. Eisen, ready? Mr. Eisen, Mr. Eisen, Mr.
Oh, I have multiple. District. All right, we're spelling everything right. Enough, close enough for government work, as they say, as I say. Let's go, yes. I feel very embarrassed that I was like hitting up everybody on Twitter and they're just an hour late. Is what it sounds like. If I'm not mistaken, they are about to start. So embarrassing. No, 10 a.m. It said 10 a.m. everywhere. Everywhere. Did you refresh the screen, Mr. Levin? Yes, I refreshed the screen many times, as a matter of fact. They got me all excited, and now nothing. Nothing. All right, let's see. Maybe the other side of the... This is the GOP stream. Let's see if the House Judiciary... Oh, there we go.
Committee will come to order without objection. The chair is authorized to declare recess at any time. We want to welcome everyone to today's hearing on the Manhattan Office. I apologize. We're like we're 62 minutes late starting, but we had an important guest to our Republican conference today. The chair now recognizes the gentleman from Texas to lead us in the Pledge of...
Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Chair will now recognize himself for an opening statement. The New York County District Attorney's Office began investigating President Trump in 2018, 6 years ago, 2018. But it wasn't Alvin Bragg, it was Cy Vance. Southern District of New York, months later, concluded its investigation into payments made by Michael Cohen and determined no charges should be brought against President Trump. Of course, while this was going on, Alvin Bragg was running for the job, vowing to go after President Trump, bragging about the number of times he had already sued President Trump. Mr. Bragg ultimately wins and takes office in January of 2022. First thing he did, the day one memo. 10-page policy memo to his staff instituting progressive, soft-on-crime, anti-victim policies. Felony armed robbery charges get reduced to misdemeanors. He instructed his staff, except for homicides, not to seek prison sentences for individuals. And guess what came next? Rising crime. During that first year, violent crime in Manhattan was at an all-time high. New York City saw a 23% surge in major violent crimes. In fact, we heard from some of these victims of crime at our field hearing up in New York City 13 months ago. A mother whose son's murderers were allowed to walk free because of Alvin Bragg's soft-on-crime prosecutors. A bodega owner who was violently attacked, yet Bragg's office initially charged him. And finally, a father whose son was attacked in Times Square because he was Jewish. And Bragg offered one of his assailants a sweetheart slap-on-the-wrist deal, even though he had previous run-ins with the law, showed no remorse, and was arrested while out on bail. A few weeks after this day one memo, Alvin Bragg told one of his prosecutors, Mark Pomerantz, quote, he could not see a world in which he would indict President Trump and call Michael Cohen as a prosecution witness. That's right, after campaigning on going after the former president, Alvin Bragg gets into office and realizes the case against President Trump is ridiculous. And that's why the Southern District of New York didn't bring it. That's why his predecessor, Cy Vance, didn't bring it. Everybody knew Michael Cohen couldn't be trusted. In fact, his former lawyer sat right in this room and told us, you can't believe what this guy says. Michael Cohen's lied to Congress, he's lied to the FBI, and he's lied to court. It's not often you can lie to all three branches of government and yet become the star witness in a prosecution of a former president. Now, what caused Alvin Bragg to do the 180-degree turn? What caused him to change? That special assistant district attorney, Mark Pomerantz. The guy Alvin Bragg had told he could not see a world in which he would indict President Trump and call Michael Cohen as a prosecution witness. That guy resigned in protest of Mr. Bragg's decision not to go after President Trump. And his fellow assistant district attorney, Kerry Dunn, resigned as well. And they leaked their resignation letter to the New York Times. And after that, the left begins their pressure campaign on Mr. Bragg, and suddenly the, quote, zombie case is resurrected. And also, never forget, in November of 2022, President Trump announced he was a candidate for president of the United States. And just a few weeks later, Alvin Bragg hires former senior Biden Justice Department official Matthew Colangelo to come up and run the prosecution. Someone who had a history of taking on President Trump and his family's businesses and had also worked for the New York State Attorney General. Alvin Bragg, the partisan DA that campaigned on going after President Trump, whose newly hired lead prosecutor for the case also had a history of taking on President Trump, had their case now in front of a partisan judge. A judge who had donated to President Biden, who imposed a gag order on President Trump, prevented an expert defense witness from testifying, and also told the jury they didn't need to reach a unanimous decision. And there is the fundamental issue. No one knows what the federal crime is. Bragg and Colangelo bootstrap charges federal prosecutors declined to bring into some kind of never-seen felony. Former Attorney General Robert H. Jackson warned us about rogue prosecutors. Former Attorney General said this in a speech 84 years ago. The speech was titled "The Federal Prosecutor." Applies to all prosecutors, though. Attorney General Jackson laid out a vision for how prosecutors should behave in a fair and just society. He stated, quote, "Therein is the most dangerous power of the prosecutor, that he will pick people that he thinks he should get, rather than pick cases that need to be prosecuted. It is here that law enforcement becomes personal, and the real crime becomes that of being unpopular with the predominant or governing group, being attached to the wrong political views, or in a way of the prosecutor, be in the way of the prosecutor himself." And that is precisely what we have here in this situation. In this situation. Alvin Bragg's prosecution of President Trump was personal, it was based on politics, and it was wrong. And we're going to hear from some expert witnesses today who will give us details into all that. With that, I yield to the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, we sit here today for one reason and one reason only. House Republicans are willing to do just about anything to protect Donald Trump from the consequences of his actions. On May 30th, a jury of his peers sitting in a state court in Manhattan convicted Donald Trump of 34 counts of falsifying business records in the first degree for paying hush money to conceal information that could have been harmful to his 2016 presidential campaign. Let's see how that all unfolded.
An unprecedented moment in American politics. Former President Trump indicted by a Manhattan grand jury.
Breaking news. It appears for the first time in American history, an American president has been indicted on federal charges.
The Justice Department unsealing the 49-page federal indictment against former President Trump for his handling of classified documents after leaving the White House.
A federal grand jury here in Washington has voted to indict the former president for his efforts to overturn the results of the 2020 presidential election.
Former President Trump has been indicted now for a fourth time. The nearly 100-page indictment was unsealed last night in Georgia.
A whopping 91 felony counts in total, 91.
The jury a short time ago alerting the judge it has reached a decision in the Donald Trump hush money trial.
91 counts.
Count 1, guilty. Count 2, guilty. Count 3, guilty.
To interfere with an
15 out of
election.
15 so far.
He became very still. He had his arms folded across his chest.
Count 31, guilty. Count 32, guilty.
His face was red. He looked upset. He had a frown on his face.
He's scared. And frankly, he should be.
Guilty on all 34 felony counts.
We arrived at this trial and ultimately today at this verdict in the same manner as every other case that comes to the courtroom doors.
Nadler.
Let me be clear.
Like he put that video together himself.
This trial was fair and just, and allegations to the contrary represent a desperate, evidence-free attempt to shield Trump from accountability. Today, we're going to hear a long list of allegations designed to undermine public faith and confidence in the jury's verdict. Do not be deceived. These are baseless allegations, and we can take them down one by one. First, Republicans claim that Judge Merchan was, quote, handpicked to handle the Trump case because he had donated $35 to Democrats in the past. This is false. Judges are assigned at random in the New York court system. With respect to Judge Merchan's $35 donation, the New York Advisory Committee on Judicial Ethics issued an opinion saying that he need not recuse himself from the case, and there is simply no evidence that any of Judge Merchan's rulings were biased in any way. Second, Republicans claim that the jury's verdict convicting Trump was not unanimous. This is absurd. The jury instructions plainly stated that, quote, your verdict on each count you consider, whether guilty or not guilty, must be unanimous. That is, each and every juror must agree to it, close quote. The verdict was unanimous on each of the 34 counts. Third, Republicans claim that all of Judge Merchan's rulings went against Trump. This is false. In fact, Judge Merchan repeatedly ruled for Trump, including a critical ruling that required prosecutors to prove willfulness under a heightened mens rea standard. Fourth, Republicans claim that Judge Merchan prevented Trump's expert witness from testifying. This is false. Trump's attorneys chose not to call that witness because he could not have testified about underlying questions of law, which is a role solely reserved to the judge. Fifth, Republicans claim that Attorney General Garland secretly, quote, dispatched Matthew Colangelo, a former DOJ attorney who served as the lead prosecutor on the Trump case, to the Manhattan DA's office as part of an elaborate ruse to plant DOJ prosecutors and state-level officers to attack Donald Trump. This is false and utterly absurd. Last week, the Attorney General clearly and unequivocally told Republicans that they are wrong. The Department of Justice has no record of any communication to the contrary, and Republicans have not and cannot produce any evidence whatsoever to support this nonsensical claim. And that's the theme for today. Republican attacks, one after another, lack any basis in truth or fact. My colleagues across the aisle know this.
and yet they repeat their attacks ad nauseum because that is the only play left in their playbook. They didn't like the fact that Trump lost in 2020. So, lacking facts or evidence to support their claims, they instead attacked our democratic institutions, basically claiming that the election was rigged and corrupt. They didn't like the fact that Trump was indicted for mishandling highly sensitive classified documents.
Hit that subscribe
so they
button,
claimed
gang.
that Trump declassified them with his mind.
Smash.
They didn't like the fact that the FBI had to send in agents to execute a search warrant at Mar-a-Lago because of concerns that Trump would destroy documents. So they claimed that the lawful execution of a search warrant constitutes a raid and a witch hunt. And now they don't like the fact that an impartial jury found Trump guilty not once, not twice, but on 34 separate counts. So they are attacking the judicial process, calling it rigged, corrupt, and pre-cooked.
I mean, it's even
without
worse, Tim.
a
It's not
shred
10
of
years from
evidence
now.
to
This
back
isn't
their
about Trump
allegations.
today or the country 10
And
years
why
from
are
now.
they
It's-
doing this?
It's happening. They're raiding
Why are they
people
sowing doubt in our
today
system?
with
Why
long
are they
guns and
using
ballistic
rhetoric that is
shields. The federal
guaranteed to
government,
generate
with the
death
police
threats against
power
the
they don't
judges and jurors
constitutionally have.
and prosecutors and police involved in these cases? For one reason only, to protect the felon. A felon who I remind
It's
you faces
insane that
an
they brought all
additional
these charges
37
against
felony
the former
counts
president, like a
related to
year
his
or two
mishandling of
after he was
classified
done in
documents.
office.
4
And none
federal
of them
counts
are
for
of any
conspiring to launch a
substance.
riot on January 6th, and 13 counts in Georgia for conspiring to interfere with the administration of the 2020 election.
If he embezzled
Within
$1
the bounds of our
billion
system of
from
laws,
the
there is
Wall
nothing
Fund or
Trump can do
something,
to escape a trial in each of those counts.
bring a charge against him for that. That
Or
is
to
not what
escape
this
a
is.
sentence
You know,
if
he's
he is
not like
found
one of those
guilty on
corrupt
any of them.
prime ministers
Trump
in
and
a
his
third world
allies know
country
this,
that have been.
and so they are moving heaven and earth to undermine the system
But even
itself.
then, usually
that
they
includes the
just,
attempt by our chairman
send
to
them
reach
on,
into the
send
New
them
York
packing.
case
They don't need
while
to-
sentencing is still pending and
He's got a
drag the
parking
Manhattan
ticket
District Attorney
outstanding from
before
10
this
years ago
committee.
they're going to bring.
That demand represents a completely unacceptable abuse of the gavel.
Sorry.
It is entirely inappropriate for us to interfere with an ongoing state prosecution, no matter how much blind loyalty you feel you owe to the defendant. It is also an effort that smacks of desperation, and it seems, from the standing of MAGA Republicans these days, that the American public has caught on. Donald Trump has faced a jury of his peers. Nothing can change that. We here will face our constituents in November. We should conduct ourselves accordingly. I thank the witnesses for being here today, and I yield back.
The gentleman yields back. We'll now introduce today's witnesses. We have first Mr. Andrew Bailey, the Attorney General of the state of Missouri. Prior to becoming Attorney General, he served as a prosecutor and deputy counsel and then general counsel to the governor of Missouri. Attorney General Bailey has also served our country in the United States Army. The next individual, I would yield to the gentleman from Texas to introduce.
It's my honor to introduce Mr. James Trey Traynor. He's a commissioner on the Federal Election Commission, where he served as chairman of the commission in 2020 prior to his confirmation. He practiced law for 2 decades with a focus on election law, campaign finance law, and ethics. He has also served on the advisory board of the Election Assistance Commission, and he's a constituent of mine and lives about 5 miles down the road around the corner from Salt Lake Barbecue. And like my wife, is a Texas A&M graduate. Great to have you here, Trey.
Good to have the Attorney General and Commissioner. Next, we have Ms. Elizabeth Price Foley. Mrs. Foley is a professor of law at Florida International University College of Law, where she teaches constitutional law, separation of powers, and civil procedure. She is also of counsel at Baker Hostetler, where she practices constitutional and appellate law. Mrs. Foley is the author of 3 books on constitutional law published by the Yale, Harvard, and Oxford University presses. And we have the Honorable Norm Eisen. Mr. Eisen is a senior fellow in governance studies at the Brookings Institute. He previously served as U.S. ambassador to the Czech Republic from 2011 to 2014. And we have had Mr. Eisen in front of the committee numerous times. We welcome our witnesses and thank them for appearing today. We'll begin by swearing you in. Would you all please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record show that the witnesses have answered in the affirmative. Thank you, and you may be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. We'll be a little liberal with that, but around 5 minutes will be great. And we're going to go right down the line. We'll start with
Yeah, I've thought about
the Attorney
that.
General, and then we'll move down the line. Mr. Attorney General, you're recognized for 5 minutes.
want to thank the chairman and the ranking member and distinguished members of the committee for having us here today. The people of the state of Missouri watched in horror as the left's direct assault on President Trump manifested itself in the form of a corrupt prosecution of the president, which resulted in an errant criminal conviction. We are a nation of laws that are supposed to be equally applied. Instead, the left has prioritized its hatred of President Trump above the rule of law. To put it plainly, the left hates President Trump more than they love this country. The term lawfare, while apt, fails to adequately convey the moral depravity underpinning this strategic attack. The Manhattan District Attorney's Office recent prosecution of President Trump represents one of the most morally abhorrent volleys in the left's ongoing barrage of lawfare. This prosecution was politically motivated and is replete with legal error. First, prosecutors are explicitly forbidden from waging politically motivated prosecutions. To the extent a prosecutor is self-interested in a case, that prosecutor must recuse himself. That did not happen in New York. Mr. Bragg was previously involved in civil litigation against President Trump, campaigned on a promise to prosecute President Trump, and then recruited the third highest ranking official from President Biden's Department of Justice to lead his trial court efforts against President Biden's political opponent. Second, the indictment charges President Trump with 34 counts of falsifying business records for making entries in records with, quote unquote, the intent to commit another crime. The charge's reference to an unidentifiable other crime constitutes a deprivation of due process by denying the president a right to be informed of the crimes for which he is charged. Third, the prosecutor sought an unconstitutional gag order in this case. There's a strong presumption against gag orders as violative of an individual's First Amendment right to free speech. Bear in mind, the right to free speech protects not only the speaker, but Americans' right to hear from a presidential candidate. Fourth, the prosecutor perverted the law to meet the facts rather than objectively apply the facts to the law. The statute at issue prohibits a false entry into a business record. However, the financial entries were authentic in that the entities listed received the funds enumerated in the documents. The prosecutor illegally bent the law to allege that these transactions were accurately recorded were for some other purpose. Fifth, the prosecutor failed to correct the court's error in instructing the jury that unanimity was not required as to the predicate offense that forms the basis for the fallacious charges. The Sixth Amendment right to trial by jury includes jury unanimity as to each element of the offense for which the defendant is tried. The prosecutor had an affirmative duty to object to this violation of President Trump's constitutional rights. Missouri has a unique history that parallels much of what recently happened in New York, with the exception that systems in Missouri countered a rogue prosecutor who filed politically motivated cases. In fact, I filed the lawsuit that ultimately removed her from office and prevented this kind of lawfare. George Soros has repeatedly funded progressive prosecutors who wreak havoc on the criminal justice system at every level. Not only do they prosecute political opponents, but they refuse to prosecute actual violent crimes happening in our communities. In fact, President Biden's Department of Justice is in lockstep with radicals like George Soros and is actively funding groups like the Vera Institute that are turning our streets into war zones. The Vera Institute, a progressive organization dedicated to undermining criminal prosecution in the United States, receives tens of millions of dollars in federal funds annually. My lawsuit to remove the prosecutor in the city of St. Louis uncovered the disastrous relationship between her office and the Vera Institute that resulted in more than a 90% non-prosecution rate of reported crimes. Meanwhile, the St. Louis prosecutor had to be disqualified from cases in which she was politically motivated. Missouri's systems worked in that the judiciary prevented her political witch hunts, and my lawsuit removed her from office after she neglected to prosecute violent crime. The same systems failed in New York. George Soros has funded Alvin Bragg's candidacy, and under his watch, the Manhattan District Attorney's Office has partnered with the Vera Institute. And in this case, the Judiciary in New York failed to disqualify Alvin Bragg from his case against President Trump. These facts, coupled with the federal and state prosecutions that have yet to play out, display a level of collusion never seen before between a corrupt Department of Justice and illicitly motivated state prosecutors. I believe the investigations and subsequent prosecutions of President Trump have been illegally conducted in coordination with the Department of Justice. That is why my office demanded communications between the DOJ, Alvin Bragg, Letitia James, Jack Smith, or Fani Willis related to the investigation or prosecution of former President Donald Trump. In order to protect the rights of all Missourians who plan to participate in the 2024 presidential election, the state of Missouri has the right to know what extent the prosecutions of prominent presidential candidates are being coordinated by the federal government, which is currently run by President Trump's primary political opponent. The credibility of our criminal justice system has been undermined and hangs in the balance. If we are to protect the rule of law, we must end the lawfare against President Trump. As a nation, we must affirmatively reject Soros-backed prosecutors who refuse to enforce the law and instead weaponize the criminal justice system to achieve political ends. As a nation, we must eliminate the Vera Institute's influence over the DOJ and our local prosecutors' offices. I want to thank the chairman and ranking member and distinguished members of the committee.
Thank you, Mr. Attorney General. Commissioner, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Chairman Jordan, Ranking Member Nadler, and distinguished members of the committee, it's an honor to appear before you today to discuss the critical issue of jurisdictional overreach in the prosecution of federal campaign finance law, specifically regarding the actions of Alvin Bragg, the District Attorney for Manhattan, in his prosecution of former President Donald Trump. No less critical, I want to highlight the inaction by the Department of Justice to defend federal jurisdiction in this case. The Federal Election Campaign Act serves as the bedrock for regulating money in our elections. It delineates the authorities responsible for enforcing these rules, vesting exclusive jurisdiction in the Federal Election Commission and the Department of Justice. This statutory framework is designed to ensure a uniform application of campaign finance laws nationwide, preventing the creation of fragmented enforcement landscape and leveraging the expertise and resources of federal agencies. District Attorney Alvin Bragg's decision to pursue charges against former President Trump for alleged violations of federal campaign finance laws marks a significant deviation from this established legal framework. By doing so, Bragg has effectively usurped the jurisdiction that this Congress has explicitly reserved for federal authorities. This overreach sets a troubling precedent for the politicization of legal proceedings at the state level. The danger here lies in the disparate enforcement standards that torture well-established federal law processes. As an example, the state judge in New York misinterpreted federal criminal mental intent standards and gave the jury an instruction which read, willfully contributing campaign contributions, but the statutory mental intent found in the Federal Election Campaign Act is knowing and willful. Now, imagine 50 states enacting the crime of campaigning by unlawful means, and 1,000 different state and local prosecutors prosecuting presidents, former presidents, presidential candidates, and any number of House and Senate candidates under varying interpretations of FECA by bootstrapping those laws through their state's unlawful means criminal code. It is also disturbing in this case what hasn't happened over at the Department of Justice. Given the clear precedent established by the U.S. Supreme Court regarding the prohibition of state officers prosecuting federal crimes, it is perplexing that Attorney General Merrick Garland and the Department of Justice did not intervene in the prosecution of Donald Trump. The DOJ's election year sensitivity policy is designed to protect the public from being influenced by legal proceedings during an election year. Had the DOJ zealously represented the United States by intervening to protect its own jurisdiction and that of the FEC, this issue might not be the predominant one of the 2024 presidential cycle. A disclosure on May 31st in unredacted FEC documents reveals that the Department of Justice conducted a year-long investigation and found no criminal acts committed by former President Trump. This revelation underscores the problematic nature of Bragg's prosecution and his intrusion upon federal jurisdiction. Again, the implications for allowing local district attorneys to prosecute based on their interpretations of federal campaign finance law are profound. Such actions risk eroding the uniformity and predictability that FECA aims to provide. For me, a larger First Amendment concern is at play here. That is the deterrent that this encroachment on federal jurisdiction will have on well-qualified candidates from seeking public office. Fearing disparate legal standards based upon their locality, preserving the centralized enforcement mechanism envisioned in FECA is essential to a fair and impartial oversight of campaign finance regulations and of our elections. Alvin Bragg's misguided prosecution of former President Donald Trump represents a clear usurpation of federal jurisdiction. Coupled with the DOJ's inaction, it's compounded the issue. The dangerous precedent of local prosecutorial overreach in matters of federal concern must be addressed to maintain the integrity of our electoral system. We must reaffirm the exclusive authority of the FEC and the Department of Justice to enforce federal campaign finance laws, ensuring consistent and impartial application across the United States. Thank you, Mr. Chairman, for the opportunity, and I look forward to your questions.
Thank you, Commissioner. Counselor, Ms. Foley, you're recognized.
Chairman Jordan, Ranking Member Nadler, members of the committee, thank you so much for the opportunity to testify today. I'm going to focus my remarks on due process as a constitutional lawyer and someone who practices in the field. Most of you went to law school, so you remember that due process is part of the Constitution that ensures that the processes employed to deprive someone of life, liberty, or property are fundamentally fair. And of course, we all learned that there are twin pillars of due process. One is notice, and in the criminal context, that means notice of the specific charge that you face, as well as the issues that are raised therein, in other words, the elements of that crime. And number two, a meaningful opportunity to be heard on those charges. And unfortunately, Mr. Trump's New York trial violated both of these twin pillars of due process. And to explain why, first of all, I've attached a flow chart to my written statement that might be helpful as I go along through my oral testimony. But I thought I'd also bring another visual of the Russian nesting dolls to give you some sense of the complexity of the theory of criminality with which Mr. Trump was faced in New York. This first doll represents the actual charges in the indictment against Mr. Trump. There were 34 charges of felony falsification of business records under New York law. And to make it a felony falsification, you have to meet all of the elements of misdemeanor falsification, which means you have to have a falsified business record with an intent to defraud.
She's wearing a Cartier tank. She's a boss.
And then to make it a felony, you have an additional element that must be proven. That additional element is the intent to commit another crime. All right, so the next nesting doll is, what is that other crime that Mr. Trump intended to commit? Well, Mr. Trump wasn't sure, and neither were his attorneys, so he asked the New York prosecutor for what's called a bill of particulars, saying, hey, please tell me what that other crime you think it was that I intended to commit. The prosecutor interestingly responded and said, hey, you don't have a right to know. We don't have to tell you what that specific crime was. And oh, by the way, without limiting the people's theory at trial,
Isn't that great, how the government gets to do that?
quote. In other words, without limiting our ability to change our minds during the trial, the other crimes that Mr. Trump may have intended to commit may include one of four things. First, New York election law. Second, New York tax law. Third, falsification of other business records, presumably other than the 34 with which he was actually charged. And finally, the Federal Election Campaign Act, FECA, right? Now, if you hear me list those four possibilities of the other crimes Mr. Trump intended to commit, you see that they're very different crimes, right? They range from state crimes to federal crimes, from misdemeanors to felonies. And within each of those crimes, there are different, or statutes, there's different sort of ways to commit a crime. So for example, under New York tax law, tax fraud was one of the statutes cited by the New York prosecutor in his response to the bill of particulars request. That tax fraud can be committed in multiple different ways under that statute. There's different kinds of ways to engage in tax fraud. FECA, as you probably know, it's the Federal Election Campaign Act, is a federal law that's over 100 pages long. And if you read it, you see that there's lots of different crimes embedded in that one mega statute. So Mr. Trump didn't know for sure what was that other crime that the prosecutor thought he intended to commit. And in fact, the first time he learned what it was during the jury instructions, when Judge Juan Merchan told the jury that that other crime was New York election law. Okay? That's far too late for due process purposes, for purposes of notice, right? That's after all of the evidence has closed. All right, so then he picked out, of those four that were mentioned by the prosecutor, New York election law. And when you look at New York election law, you see even further that embedded in it, there's another predicate. In order to violate New York election law, you have to basically interfere with an election by quote-unquote unlawful means. You say, well, what does unlawful means? Unlawful means that the way that you committed the violation of the New York election law was itself unlawful in some way. So there's a second predicate crime buried in there, right? And then you say, well, how do I know what those unlawful means are? And Mr. Trump had no notice of what those unlawful means were because unlawful means was embedded in the New York election law, which he didn't even know was the first predicate for the basis of the felony falsification charge. And the first time Mr. Trump realized what the unlawful means could be for the basis of the New York election law was, again, during the jury instructions by Judge Mershon. And at that point, Judge Mershon instructed the jury, and I wish I had 3 of these, but I only have 1. I got these in Russia, actually. And the 3 means that Judge Mershon pulled out of the sky, right, were number 1, FECA, again, the federal election law. Number 2, falsification of other business records, although he didn't specify which ones. And number 3, and this is kind of fascinating, quote unquote tax laws, which Judge Mershon's instructions said could include not only state law, but federal tax law and local tax law as well. Now, to make matters worse.
You can finish up real quick. I apologize. We got just a
Hold it up.
Yeah, if you can finish up real quick.
Sorry. To make matters worse, Judge Mershon instructed the jury that they need not be unanimous in picking out which one of these 3 means by which they could convict Trump. This is a travesty of justice. It's clearly a violation of due process. And if anyone would like to ask me about
Mr.
the
Chairman,
Supreme Court's decision in Shad on unanimity of means,
Point of order,
I'd be glad
Mr. Chairman.
to give further detail. Thank you.
Gentlelady yields back. The gentleman, the ambassador is recognized for 5 minutes.
Thank you, Chairman Jordan, Ranking Member Nadler, and distinguished members of the committee. I appreciate you inviting me back today for this hearing. You may notice that I'm not turning my microphone on and off. Today is the Jewish holiday of Shavuot, and we do not operate electronics on our holidays. I didn't think I would be able to come at all, but my rabbi gave me permission when I explained the significance of today's hearing. I was in court throughout the 6-week plus Manhattan criminal trial of former President Donald Trump for interfering in the 2016 election and covering it up. I want to make 3 points today. First, a jury of Mr. Trump's peers in the city where he lived and worked most of his life found him guilty. I spent most of the trial watching them, and unlike some in court who dozed,
wondering if
they
was the
paid
Democrat
extremely
or the witness?
close attention
This guy.
throughout. The jurors got it right. Witness after witness, formerly inside Mr. Trump's orbit, supported both parts of the jury's conclusion. First, that Mr. Trump intended to influence the 2016 election by unlawful means, including in the form of a $130,000 payment to Stormy Daniels to benefit his campaign, over $127,000 in excess of the legal limits. Second, that Mr. Trump covered it up through 34 false business records that disguised that repayment of that excessive contribution as a legal expense. The jury were not the only ones who got it right. So did the judge. I know this may astonish some who were fed a steady diet of disinformation about him, but Justice Juan Mershon bent over backwards to be fair to the defendant. Why should Mr. Trump have been allowed, for example, to act in contempt of court by violating the gag order no less than 10 times before he was warned that the 11th violation would lead to more serious consequences? Justice Mershon was judicious on that and many other occasions, as I believe the appellate review will demonstrate. Second, the jury found Mr. Trump lied to voters and covered it up with phony documents. Does that sound familiar? It should, because we saw this pattern repeat in 2020 with the big lie that Mr. Trump won the election. The false documents in 2020 were fake electoral certificates that were part of a scheme to overturn the legitimate outcome of the election in...
Remember how they were like, just the day after the election, they're like, it's the most secure election there ever was. Like BS. And one of their lines was, the American election system is like a quilt. It's patchwork. Different everywhere you go. It's the people in charge of that are like your grandma and your grandpa, and they don't know what they're doing. So you
wins. That brings me to my third and final point, where the real threat of the politicization of the justice system and the weaponization of government lies.
The attacks on the trial and verdict by the former president and others are politicizing a crime, falsification of business records, that has been prosecuted about 10,000 times in New York since 2015. Mr. Trump should not be treated any differently, no better, no worse, than those other defendants who falsified documents. His politicization of the case has led to a staggering amount of confusion, such as that there was no underlying crime specified that made his document falsification a felony. Not so. I brought an exhibit also, the May 12th, 2023 Bill of Particulars. That's their response to the Bill of Particulars that did specify the crime. And I have a pile of other documents here showing that that happened over and over again. As bad as all that is, the worst politicization is the call by Mr. Trump and others to baselessly prosecute his adversaries in retaliation for the verdict. Just last week, Mr. Trump pointed to his own prosecution and then said, it's very possible it's going to have to happen to them, to his political opponents. Those words are all the more chilling because they are not isolated to the issue of this trial. We should take them as a warning of what is to come should he return to office, starting with his promise to be a dictator on day one. That would be the real weaponization of government, not Mr. Trump's being held accountable by 12 of his fellow citizens. Thank you.
Gentleman yields back. The gentleman from Florida.
What's funny was
we are here at the hearing on the Manhattan District Attorney's Office, and the essential ingredient we seem to be missing is the Manhattan District Attorney, which I guess, Mr. Roy, would be a lot like going to the Salt Lick Barbecue and not getting the moist brisket. Now, to Mr. Jordan's credit, great credit, he sent a letter to Mr. Bragg on May 31st inviting him to come participate, and we got sort of a nasty gram back from Mr. Bragg on June 7th. Mr. Chairman, I seek unanimous consent to enter into the record the June 7th response from AG Bragg.
Objection.
And, I'm sorry, DA Bragg. And in this letter, I'm going to quote from it, Ms. Foley. Bragg says, this office is committed to voluntary cooperation. Do you believe that?
No.
The letter continues, that cooperation includes making the district attorney available to provide testimony on behalf of the office at an agreed upon date. Do you believe that?
I'll believe it when I see it.
It goes on to say that they're evaluating the propriety of allowing an assistant district attorney to testify publicly about the matter. Now, that assistant district attorney is the one who downstreamed from DOJ, right? So you think they're going to provide Mr. Colangelo here to answer our questions?
I would not expect Mr. Colangelo to show up.
And do you base that opinion on the lawsuit that Alvin Bragg filed against Jim Jordan in his official capacity in the Committee on the Judiciary?
I saw some of that, yeah. I mean, look, you have a legitimate legislative purpose to be inquiring as to what you're doing, so they have no leg to stand on.
But they're not going to come because we ask. And they're not going to come because they say so. And we learned that by observing our dear friends at the Oversight Committee. Because this will surprise a lot of Americans. After hearing the enthusiasm around oversight of the Biden crime family, we never sent a subpoena to Hunter Biden to give live testimony before Congress. Let that sink in. The Republican House majority has never subpoenaed Hunter Biden for live testimony in public. We've never done it. And I worry that, we're going about the same kind of process here, and we may end up there in July, right after sentencing, with an empty Alvin Bragg nameplate and an empty Matthew Colangelo nameplate. And then we'll start the process again on letters and subpoenas and accommodation, and I've just grown tired of it. And I think you're right, Ms. Foley, that this is all professional wrestling. There's no real effort to bring these people to bear. So,
will the gentleman yield for a
no,
question?
one second, I got a motion. Mr. Chairman, I move under Committee Rule 4 and Clause 2M of House Rule 11 to require the attendance and testimony of Alvin Bragg and Matthew Colangelo on July 12th to discuss their involvement in the Trump prosecution, including their office's coordination with the Department of Justice.
Mr. Chairman. Mr. Chairman.
Gentlemen, ranking members recognized.
It's a little absurd because Mr. Bragg and Mr. Colangelo have already agreed to appear before the committee on July 12th. We have a letter to that effect, so there's no point requiring them to do what they've already said they're going to do. The committee asked them for to appear. They asked them to appear today. They made the point that they did, or Mr. Bragg, I should say, made the point that he didn't think he should appear before the sentencing on July 11th, but he'd be available thereafter, and he's agreed to come on July 12th.
Mr. Chairman, this debate's out of order.
You made a motion. It's not out of order.
No, you have to seek recognition pursuant to debate on the motion. You can't just inject.
I recognize it.
I'm still on my time. I'm still controlling 2 additional minutes of time.
You'll get your time, man.
I have a letter here. No, my point is simple. The committee requested them to appear, Mr. Bragg and Mr. Colangelo. They've agreed to appear. They plan to appear on July 12th. I don't know what this debate is about. I yield back. Oh, and I'd like unanimous consent, Mr. Chairman. Yes, unanimous consent to introduce into the record a report from Fox News headlined.
Without objection.
I object pending consideration of my motion.
Hang on, I want to deal with.
Let me finish.
I want to deal with Mr. Gates' motion. Then we'll take your unanimous consent. Mr. Bragg and Mr. Colangelo have agreed to come on the 12th. If they don't show up on the 12th, they will be subpoenaed. So I would ask the gentleman if he could withdraw the motion. They're coming. We worked hard over the weekend to make sure they're coming. And if they change their mind, they will get a subpoena from the committee requiring them, compelling them to be here. And then if they choose to go to court on that, I think we'll beat them in court like we did the first time when we got Mr. Pomerantz to come testify in front of the, come be deposed in front of the committee.
Time then becomes determinative. The problem is, if we're going to bring these people in, let's go. I've made a motion to subpoena these people now, pursuant to the rules, and I want to vote on my motion, or I want someone to move to table it.
You made the motion to subpoena them for the 12th?
I moved under Committee Rule 4, Clause 2M of House Rule 11, to require the attendance.
I move to table the.
That's fine.
I second that.
That's not debatable.
Gentleman's made a motion. The motion to table is not debatable. Those in favor of.
The chairman? They talking about what the heck they're gonna do next. Hold on, my kid left the door open.
Committee will stand in recess.
And we're back. What happened? Hold on, let me just replay what the last thing that happened was.
I move to
Require the
table.
attendance.
I move to table the.
That's fine.
I
Let's take a
second
vote.
that.
That's not debatable.
Gentleman's made a motion. The motion to table is not debatable. Those in favor of...
Okay. Did they say how long? Sorry, gang, my kid came in. The neighbor's got a chicken, now he wants one. Well, what the heck? Fine, we'll be in recess for now. What you gonna make me? I didn't miss any. I just wanted to see if there was if he didn't gavel out. Did he even say they were in recess? I thought they were just tabling like Matt Gates's motion. Tabling means like put it aside, I'm pretty sure. Tabling motion in committee means to postpone or suspend consideration of a bill or discussion. The motion is not debatable and requires a majority and a second to pass. The bill remains in committee and is not reported to the floor, effectively killing the measure. But there's no bill here. I mean, the witnesses showed up. They're testifying. They're in recess. They haven't adjourned. So they're coming back. I think they're just figuring out what to do next. Unless I'm misreading this, guys, let me know. DFT asks, good question. I think he should go after people like the intelligence officers who fabricated a letter saying that he was involved with Russia. To let those people stay in that's insane to me. To let them keep their security clearances. I don't know how you go after. You don't jail them for life. You definitely strip them of their security clearances. I mean, the swamp needs to be drained, right? But I don't think he really understood what that meant until they turned on him. I think he needs to do something. Get rid of those people. Send them away. Let's see what's happening on Twitter. It could be... I'm so confused. They're trying to kill my stream. Just kidding. I'm just kidding. I'm looking for something interesting. I got nothing. Let's see what's going on in the New York Post. SCOTUS makes unanimous ruling on abortion pill access. The Supreme Court made a unanimous ruling on a bid to ramp up restrictions on access to some pill, part of a two-drug regimen frequently used to cause abortions. Supreme Court rejected the challenge to the abortion pill in a unanimous ruling. In case you were wondering. Kanye spotted flying economy with the rest of us. That's all I got. I don't know. Who wants a mug? I should probably, yeah. You hear my kids upstairs? I don't know. We're in recess. I don't know how long we're going to be in recess for. It's a good time. Good time for coffee. Let me leave. We're back. The kids did not do too much damage. Let me just figure out the mug situation. Which thing are you? And we can go back to watching my video, the Kennedy one, while we're waiting. Why not, right? Bingo. We're back. We're back.
You apply the relevant case law. You were reversed, right?
The Third Circuit reversed my decision, yes.
Okay. Do you remember a case called Hassel v. Centric Bank?
What did I miss?
I vaguely recall that case, yes, Senator.
You were reversed, weren't you?
I believe the district court failed to adopt declined to adopt my recommendation,
Okay.
yes.
Do you remember a case called Ramsey v. Amtrak?
Yes, I do.
And the higher court reversed you in that case too, didn't they?
The district court concluded that I was correct in finding that the petitioner did not pay a filing
I would
fee.
like to
And
talk about that briefly, because there's a real difference, I think, in the Young Thug case versus the. Okay, so we have an attorney being held in contempt, right? So, I can't take her likeness. That's my only hurdle there, Matt. But DWS, and who would want to take that likeness? But so Brian Steele held in contempt for not divulging information who he heard a piece of information from in an ex parte meeting. A witness who was already sworn in the judge's chambers. Somehow, Brian Steele learned about information from that meeting. It sounds like the Judicial's coming back. But now you look at Garland, who's going to be held in contempt of Congress. Different kind of contempt, no jail time, but it does open him up to civil criminal liability. Different kind of contempt, but also when you think about it, you have a defense lawyer who's standing up against the government versus the government
Mr. Chairman, I will
who's just standing up to
my
defend the
motion
president and the Biden.
based on the
It's a big
representations
difference.
not only that you've made, but
Big
that the
difference.
ranking member has made in our colloquy previously that Mr. Bragg and Mr. Colangelo will be here and willing to answer our questions. Ms. Foley, I wanted to come back to you. You'd made mention of this theory of unanimity,
Brian
and I
Steele,
wanted to give you a chance to talk
YSL,
about that case law a little
punching
bit
up.
you were referencing.
Oh, yeah, thanks. In
punching
fact,
down.
Professor Eisen and I were just sort of debating that case, Shad, from 1991. So Shad is a case where Arizona had this first-degree murder statute. And in order to commit first-degree murder under that statute, you could either have premeditated murder or you could have felony murder. And the question was whether or not that the jury had to be unanimous in its conviction under first-degree murder, whether they had to make a specific finding that it was premeditated or they had to make a specific finding that it was felony murder. And that case is very split. There's like a 4-1-4 split amongst the 9 justices in Shad. The main plurality written by Justice Souter says, well, in a case like that, that statute, the Arizona legislature looked at the crime as first-degree murder and said that if you commit it either by premeditation or by the commission of, during the commission of a felony, you sort of have equal sort of moral culpability to warrant the first-degree thing. And so the jury doesn't have to be unanimous as to whether it's one or the other, all right? But along the way, at the end of that, they said, a point of caution, that if the means by which a crime could be committed are sort of too capacious, there might be due process problems. And then you have a Scalia concurrence that reiterates that concern and says if you have sort of an umbrella crime, it would violate due process. And then you get 4 other justices in dissent who are even taking a tighter position, saying if it's an element of the crime, it must be unanimous.
It almost seems like I get the Russian nesting dolls, but it's almost like a Mr. Potato Head doll, where you're sticking the wrong parts on and ending up with quite an odd-looking legal feature.
Well, yeah, and the thing about New York's election law is it can be violated by any unlawful means, quote unquote. That's the language of the statute. Now, any unlawful means any unlawful means. It can mean a local crime, it could be a state crime, it could be a federal crime, as opposed to the Arizona statute, which was upheld, only gave you two choices. It was either premeditated murder or it was murder in the commission of a felony. That's much tighter.
Yeah. I see our time has expired, but it sounds like a real constitutional due process issue as applied in this prosecution. I yield back.
Correct.
Gentleman yields back. Gentleman from New York is recognized for 5 minutes.
Thank you, Mr. Speaker, Mr. Chairman. Ambassador Eisen, I want to talk about some of the disinformation that's been spread about the trial in New York. Republicans have attacked Judge Merchan as biased and have suggested that he continually ruled against Trump. What is your response to that allegation?
Mr. Chairman, I was present throughout the trial, and I thought that the conduct of the judge was the exact opposite of bias. He was scrupulously fair. He upheld dozens and dozens of the objections that were articulated by the defense. At times, for example, during the testimony of Stormy Daniels, when the defense did not object, he objected for them, sua sponte, to limit the testimony. I would not have allowed Donald Trump to violate the gag order 10 times, as you heard in my opening testimony, before threatening him that the 11th would require more dire consequences. One of the biggest fights, Commissioner Traynor referenced this, was over willfulness. The judge actually adopted the instruction that was proposed by the defendant and his counsel. I could give you many, many other examples. I thought it was one of the outstanding jobs of judging that I have seen in my over 3 decades in court.
Now, Ambassador, Republicans have alleged that it would be impossible for Donald Trump to get a fair trial in New York City. Is there any shred of validity to this?
I watched that jury, Mr. Nadler, and they paid close attention. Many of them took notes throughout. They included those who said they followed Mr. Trump's statements on Truth Social. The notion that a jury of Manhattanites, where Mr. Trump chose to live and work, where the offenses were committed, cannot sit, is really wrong, and I think it's not fair to these 12 ordinary Americans who performed their duty in our rule of law system.
And Republicans have also alleged that Donald Trump would never have been charged with felony falsification of records if his name were anything other than Trump. In fact, this is a common charge in New York. The Manhattan DA's office has pursued these cases 120 times since Bragg took office. Isn't that correct?
That's right. Mr. Bragg has.
Is there any evidence at all that Donald Trump is being politically and unfairly targeted?
Since we're doing exhibits, I thank Professor Foley, a trial lawyer. I love exhibits. For my book, I may even borrow her nesting dolls at some point if the chairman will permit. For my book, Trying Trump, I surveyed almost 10,000 New York falsification of business records cases. This is a crime that is regularly charged. If you do the FBR in New York, you do the time. So there's nothing unusual here about charging false documents.
Thank you. MAGA Republicans' attacks on Alvin Bragg should not come as a surprise. It's a clear pattern. Just look at how Republicans have viciously and baselessly attacked Special Counsel Jack Smith, who was overseeing the 2 federal prosecutions against Trump and conducted the investigations into Trump's criminal behavior. They have desperately tried to discredit Smith to lessen the effects that the indictments have had on his reelection bid, despite the mounds of evidence against him. The former president called Smith a lowlife who is nasty, rude, and condescending, a Trump-hating prosecutor, a disgrace to America, and a very vulgar profanity that I won't repeat here. He even brought Mrs. Smith's family into the tax, saying, quote, Smith's wife and family despise me much more than he does, and quote Mrs. Smith's team, thug prosecutors. These attacks on Smith clearly mirror the attack on Bragg. Why are Republicans going to such lengths to attack these prosecutors? And what are the benefits of delegitimizing them?
Because Mr. Trump is guilty of interfering in the 2016 election and covering it up with 34 false documents. And because the American people understand that that is a disqualification for a public figure in our country, and because that pattern was exemplified again in 2020, is a threat for 2024, and these attacks on prosecutors, juries, judges are of a piece with Donald Trump's promise to be a dictator on day one. That is why they are pushing back.
Thank you. I yield back.
Gentleman yields back. The gentleman from Arizona is recognized.
Thank you, Mr. Chairman.
I can't wait for Hagman. Biggs,
I'll ask you, Mr. Bailey, do you know why Alvin Bragg originally declined to move forward with the prosecution of Donald Trump?
I believe the reasonable inference to draw is that the charges aren't supported by the laws or the facts.
So let's talk about a guy named Mark Pomerantz. So Mark Pomerantz and his colleague, Mr. Dunn, resigned from the office because they felt that Mr. Bragg was not going to go forward with the case. And so he issued a statement. But in analysis, if you start looking at what Mr. Pomerantz said, he said, many members of the team did not think that they could prove Trump committed crimes. Many did not think the New York State criminal charges advanced by Pomerantz applied to Trump's conduct. In his book, he writes, many of the lawyers were relentlessly negative. There were references to our case as weak. One lawyer opined that it had many fatal flaws. Another expressed a view that the case may be way out there. It's not the strongest case in the world. If you go on, there were defectors from the Trump investigation. All of this is taking place from December of 2021 all the way through February of 2022. Now, why is that important? Because I want to get to this, Professor Foley, because there's a timeline issue, and you're talking about due process. And so due process is, you've mentioned two pillars, but I'm going to suggest that if you have an infirm prosecution and they're looking to find a way to prosecute because it's a person as opposed to the case. So here's the timeline, which may seem coincidental, but this is exactly what happened. November 7th, 2022, Trump teases. He says, I have a big announcement coming up. September 9th, 2022, at a press conference, Joe Biden says, we just have to demonstrate that he will not take power if he does run, making sure he, under legitimate efforts of our Constitution, does not become the next president. On November 15th, Trump announces his run. Now, here's where it gets interesting. On November 18th, Matthew Colangelo, number 3 in the DOJ, resigns. He gives a 2-week notice in a letter, and he's going to end up quitting his job at DOJ on December 2nd. He's going to work for Manhattan DA Alvin Bragg's office beginning December 5th. And nobody can tell us from DOJ or Alvin Bragg how they even, nobody seems to know. Just apparently, Colangelo just shows up in the office one day. Point 2, on that same date, November 18th, Merrick Garland appoints Jack Smith on 2 cases against Trump, one in Florida and one in Washington, D.C. Number 3, same day, November 18th, Fannie Willis's paramour, Nathan Wade, spends 8 hours in meetings with White House lawyers. And it wasn't too long after that indictments start falling into place. And we could go through those. I wanted to ask you, Ms. Foley, if a prosecutorial agency is actually searching for crimes because of an individual, and they've stated it. Don't forget Mr. Bragg, and I'm leaving out all of his campaign promises to get Trump. Couldn't name any kind of thing that he had done wrong, but he's going to get Trump. Is that antithetical to the very notion of due process in and of itself?
Yeah, you ask a really interesting question. Yes, the short answer is yes. There is a line of Supreme Court jurisprudence beginning with a case called Rochin versus California in the 1960s, which establishes what's called the shocks the conscience test for violation of due process. You may remember that from law school. It's where your stomach got pumped forcibly against his will.
Yeah.
But since Rochin was decided, there have been other Supreme Court cases. There's one called Exrel v. Ton. There's one called Caperton involving judges. And this line of jurisprudence under due process says that if you can establish that there was bias by a prosecutor, an investigator, or a judge that shocks the conscience, it's a due process violation as well.
Right, so when we start looking at this, and you realize that there was no theory of the case that seemed to work. I mean, that's from Mr. Pomerantz's testimony. They couldn't come up with a case. You have prosecutors saying, we can't find anything here. And then all of a sudden you get jury instructions like you have here. How antithetical to that is to due process?
Well, I think when you piece all those pieces of evidence together, they paint a pretty compelling picture of bias. And, you know, whether or not it would shock, you know, the left side of the aisle's conscience, I don't know, but it certainly would shock mine. I'm trying to be pretty objective about this. You know, it's a high bar to shock someone's conscience, but, you know, basically the idea is, you know, if you're doing the Attorney General Justice Jackson maneuver of picking the man and pinning some crime on him, then yes, I would hope that would shock your conscience.
Thank you. Yield back.
Gentleman yields back. Gentleman from Tennessee is recognized.
Thank you, Mr. Chair. This committee has engaged in many off-the-wall, pointless, politically driven hearings this Congress. Seems to be the mode. We are in the basic format of trying to do everything we can to defend one of the most lawless people in this nation's history, Donald Trump, who has been found civilly liable numerous times in New York for tax fraud, for rape, for defamation, and for violating the New York State tax laws. And now, 34 times for a felony and a criminal action for interfering in business records and interfering in the election of 2016. Now, of course, he's got other federal cases coming in Florida, where he has his friend, Judge Eileen Cooper, whatever her name is.
Cannon.
And he's got Georgia, and he's got Jack Smith on overthrowing the government and January 6th. But this committee concentrates on defending him and bringing up his case.
Jack Smith,
we've got
not a
crime
friend of the
going on in the
channel.
country. We've got immigration problems in the country, problems at the border, but nothing's more important than defending the #1 person criminal, civil defendant and criminal defendant in this country in the history that I can remember over the years. Nobody has been in court so many times and had so many losses. Yet we defend him here. This is an attack on the rule of law and on democracy, and it's a very, very unfortunate. These are political purposes that this committee has publicly, aggressively, and despicably tried to intervene in a criminal proceeding. We are a nation of laws, and those laws are enforced through the judicial system. The federal government has specific duties, and state governments have specific duties. Both are equally bound to satisfy the principles of due process and equal justice under the law. But this isn't what we're looking at here. We're looking at what the GOP has done to try to run this committee as a Trump legal defense team. I mean, they've just met with Mr. Trump over in the Capitol Hill Club, and I'm sure he did a Harvey Korman impression of, you go do that voodoo that you do so well, when he sent the Klansmen and the Hells Angels and all the other despicable characters round up together to go into Rockbridge. They're here doing that voodoo that they do so well. And they're losing, as Trump and his lawyers lost in Manhattan. 34 times a felon. And they've tried to say, this is about you, not about Trump. Well, it's malarkey. Ambassador Eisen, as a general rule, judges interpret the law and juries are finders of fact. Can you please tell us what that means and explain it to the people here who might not have an understanding of that theories, and what happened in New York?
The principle that judges interpret the law and juries find the facts is a foundational one in our American rule of law, Anglo-American rule of law system. The reason we ask judges to interpret the law is because they have the expertise in what the law means. The reason we ask juries to determine the facts is because in the American justice system and in its role as a foundation of our democracy, we trust the fate of a criminal defendant ultimately to their fellow Americans. That is exactly what happened here. One of the many canards that we've heard, Mr. Cohen, is that one of Trump's witnesses, former FEC Commissioner Brad Smith, who I've known since we were in law school together, I edited his note, was prevented from testifying? No, he was welcome to testify. He was free to testify. The only limitation was he was not allowed to instruct the jury on the law, because that is the job of the judge.
And you saw Judge Mercan preside over this case.
Every day.
What kind of job did he, what you saw and what you have heard from others, did he perform?
I thought that everyone in the case, including Donald Trump's own defense lawyers, who I praised, I wrote a daily trial diary published, and I dedicated one to singing their praises myself as a...
So Mercan was highly rated.
Mercan was one of the great judges that I've seen.
Thank you. I've got it. Ms. Foley, one question. Is Trump in one of those nesting dolls underneath Putin?
Where? What? Which?
That's the ones I've seen. I yield back the balance of my time.
Gentleman yields back.
Mr. Chairman, I have some UC.
Gentleman has a unanimous consent request.
Thank you. Article from CNN, former President Donald Trump announces White House bid for 2024. Article from The Hill, Biden suggests Trump will not take power again if he runs in 2024. New York Times article from December 5th, 2022, Manhattan DA hires ex-justice official to help lead Trump inquiry. February 7th, 2023, Pomerantz versus Pomerantz, an annotation of his leaked resignation letter in Manhattan DA Trump investigation. These from Business Insider, Donald Trump again teases 2024 presidential bid, saying he'll make a big announcement on November 15th, same day Mike Pence's memoir is scheduled to be published. February 23rd from the New York Times, two prosecutors leading New York Trump inquiry resign, clouding case's future. May 6, 2021, FEC drops case reviewing Trump hush money. From Washington Examiner, for prosecutor Bragg, Trump indictment is campaign promise kept. And Biden's number 3 man at DOJ resigned to join Alvin Bragg's Get Trump team on November 18th, 2022.
Without objection.
Thank you.
Gentleman from California is recognized for 5 minutes.
Thank you, Mr. Chairman. Of course, the leftist lawfare didn't start here. I think it started when the Democrats used the IRS to target Tea Party volunteers for harassment and intimidation in advance of the 2012 presidential election. In the 2016 presidential election, the FBI, the DOJ, and our intelligence agencies used their power to legitimize the lie that had been concocted by the Hillary Clinton campaign that Trump was colluding with the Russians. Despite knowing this was a lie, these agencies used their powers to legitimize it, to authorize spying on the Trump campaign, and to terrorize its supporters. And when this failed, they continued to pursue it, to undermine the Trump administration, question the legitimacy of the election, and shook this country apart for more than 2 years before the lie was finally fully exposed to the public thanks to the Inspector General's reports. Then we have the 2020 presidential election. Hunter Biden's laptop contained emails that clearly documented long-standing influence peddling scheme involving the Biden family, in which millions of dollars were paid. Yet 52 high-ranking intelligence agency officials signed a letter circulated by the Biden campaign calling it Russian disinformation. And although the DOJ had that computer in its possession and knew it was authentic, they suggested otherwise and then used their power to pressure social media companies to censor and suppress that story. Pollsters have reported that action alone could have decisively influenced the 2020 election. And now we have this. And I'm sorry to inform the ranking member, but Jack Smith was one of the principal figures in the IRS scandal. He had a history of prosecutorial misconduct, culminating with the unanimous reversal by the U.S. Supreme Court. Yet he was the one appointed by the Biden administration to try to put their chief political opponent in jail. Biden's Attorney General personally approved a raid on a former president's home despite strenuous opposition by career DOJ officials and by the local field office that would normally have had jurisdiction. Alvin Bragg, who campaigned by boasting he'd prosecute Donald Trump, was joined by the number 3 official in the Biden Justice Department. Nathan Wade, named prosecutor by his paramour, Atlanta DA, spent 8 hours consulting with the White House counsel at the White House before filing these felony charges, not to mention the multiple failed attempts by Democrats to throw Trump off the ballot. This administration, its Confederates, have broken every political norm, every civil tradition, every due process protection that shielded Americans from the convulsions suffered by banana republics. And we can now clearly see the full power of leftist lawfare. We always thought this couldn't happen here, but it has. And my question is what can be done by Congress, first of all, to close this Pandora's box and assure that it is never opened again? Mr. Bailey?
I think this body has a duty to erect a wall of separation between tech and state to prevent government censorship of conservative voices on big tech social media platforms. As you pointed out, the deep state has actively suppressed information that interfered with the 2020 election. I think that will continue to happen as we move into 2024. And I think the distinguished member is absolutely right that we've got to stop looking at lawfare in terms of trees and start seeing the forest for what it is. It's censorship. It's civil suits. It's President Trump being unconstitutionally stricken from the ballot in states. It's now criminal charges.
It's the turning of the most terrifying powers that government possesses against its own citizens to influence elections. And this has been going on now through several cycles, and now it's getting to a whole new level. Mr. Trainer?
Thank you for the question. I think it really comes down to the fact that we have to get away from allowing government to be the weapon to interfere in political participation.
How do we do that?
I had the opportunity last year to testify before the House Administration Committee on this very issue of how complaints are filed with the Federal Election Commission and used to do nothing but go investigate political opponents under the guise of the federal government conducting a legitimate investigation, and they ultimately turn out to be nothing at all. In fact, the most infamous one that I talked about was a gentleman who spent $348 on a Facebook page. The allegation against him was that he had spent $23,000 on a Facebook page, and he spent 3.5 years being investigated.
Right, and word gets out to anybody else. Don't even go near the political process because you will expose yourself to this kind of liability. I know Tea Party volunteers who today won't go near politics for fear of invoking the harassment of the IRS. What really frightens me is what happens to our country when if Trump narrowly loses the election and the case is then overturned and repudiated and exposed by the higher courts. That could tear our country apart. Ms. Foley, final word?
Well, I mean, I think there are a few things that at a minimum should be done. One is to defund the district attorneys and actors who engage in these nefarious acts. Two, I think the Congress needs to use its oversight authority. It has clear oversight authority under the Civil Rights Act to make sure that law is not weaponized to prevent people from exercising their First Amendment freedoms and other constitutional rights. And I think that's really a pattern that's going on today. I think there's mass intimidation through lawfare and other means to intimidate, especially those on the right, from speaking their mind, from gathering, from assembling, from protesting. I think also we're, to a certain extent, we're late to the game as conservatives and Republicans, but we have to start engaging in lawfare of our own. I think there's various ways, for example, that Mr. Trump, if he wants to.
Well, my time is up, but I hope we don't do that. We must never allow the left to become our teachers.
Well, but there's good lawfare and there's bad lawfare.
The time of the gentleman has expired. The gentlelady from California is recognized for 5 minutes.
Thank you, Mr. Chairman. I want to start off by recognizing that the felony convictions of a former president represent a first for our country, and that is solemn. I don't celebrate these convictions. It's disappointing when crimes are committed, but it may be even more disappointing when our country's justice system gets criticized for political ends. I, for one, don't always agree with the outcome of cases, but I do respect the process and especially the public servants who do their jobs. Now, some of my colleagues on the other side of the aisle claim the verdict against the ex-president is, and these are all quotes, a travesty, rigged, a sham, that the jury of peers who assembled to do their civic duty delivered a, quote, rigged verdict, that a defendant afforded due process was part of a, quote, witch hunt, that the DA is, quote, corrupt, the judge is corrupt. Corrupt seems to be a big catch-all. I saw a judge that made rulings in favor of both the defense and the prosecution, and who provided clear, lawful instructions
because they
to the
wouldn't
jury.
allow it to be
Now, some of my colleagues say
publicized in
the
a real
Department
way.
of Justice, a federal agency that is part of the Biden administration, somehow directed the Manhattan District Attorney to indict Mr. Trump in a New York State case. Ambassador Eisen, can you please help correct that specific fallacy? What jurisdiction was involved with this hush money and election interference case? The state of New York or the federal government?
This was a case that was brought by the Manhattan District Attorney under New York state law. The federal government had no role in that. Is a fundamental misunderstanding, Ms. Lofgren, of our federalism to confuse the role. It's a conspiracy theory, and the Department of Justice just this week debunked that conspiracy theory with the AG issuing a letter saying there's no evidence.
So it's fair to say that the Biden administration was not involved in this case?
Not whatsoever.
Okay, and just to make things clear, it's fair to say that President Biden himself was not involved in this case?
Not involved in this case, and indeed has given extraordinary latitude even on the federal side to his own Department of Justice, including to prosecute his own son.
In addition to muddying the waters about the current administration's involvement, the loud criticism, ironically from some who say they back the blue, can really erode Americans' faith in the justice system. Now, that is a problem for basic law and order in our country, and I think it also puts lives at risk. The number of threats targeting federal judges has more than doubled over the last 3 years, and at the local level, threats and harassment against local public officials rose last year too. Now, Ambassador Eisen, can you please talk about these increased threats to public officials as well as distrust in the system? How harmful both of those could be to our country's independent judiciary and really our democracy?
They're devastating, Ms. Lofgren, and one of the worst outcomes of the former president's incessant flow of disinformation, the attacks that you describe on the judge, the jury, the prosecutor, the system, is to incite those threats. We know that his incitement led to the tragedy of January 6th. We saw that in this body. But the constant flow, when I read the well-founded factual predicate for the gag order in this case, the sheer number and explosion of threats against the DA, they documented hundreds of these threats that were received. It's chilling. That is a tragic consequence of Donald Trump's irresponsibility.
Can democracy survive if the rule of law is eroded?
One of the privileges of my life was to sit on the dais in the first impeachment of the former president between the ranking member and Ms. Lofgren. That process demonstrated to me that a vibrant rule of law is the foundation of a strong democracy. I believe our democracy will survive, but we have not seen such a profound internal threat as this promise of day one dictatorship since, in my view, the end of Jim Crow or the beginning of the Civil War.
Thank you. Mr. Chairman, my time has expired. I yield back.
Gentlelady yields back. Commissioner Traynor, I want to read from your testimony. They have sat idly by and allowed a state officer to assert federal jurisdiction where they themselves had taken jurisdiction and couldn't prosecute. I want you to unpack that sentence for us again real quick.
Thank you, Mr. Chairman, for the question. The Department of Justice, all of these claims with regard to the $130,000 from Ms. Daniels stem from a complaint that was filed at the Federal Election Commission following the 2016 election.
Which you guys were investigating.
We were in the process of investigating that.
And the DOJ came to you and said, stand down, we're taking over, and give us your information.
They asked us to abate that and several other
DOJ
matters.
meeting the Southern District of New York.
That's correct.
They took your information, and you guys voted to stand down and give it to the federal authority, right?
That's correct, Mr. Chairman.
And they determined that there was nothing there to prosecute other than Michael Cohen.
That's correct. Now, they took a very long time in doing it, and when they sent it back to us, we had no more authority to investigate because they sent it back to us, and we were barred by the statute of limitations from even investigating the normal civil things that we would look at with regard to those type of expenditures.
But your point here is they've sat idly by and allowed a state officer to assert federal jurisdiction where they themselves had intervened, to use the word, and taken jurisdiction from you and concluded there was nothing there regarding a federal statute, right?
That is
a, quote, federal crime that they come up with somewhere.
That is correct, Mr. Chairman, and I don't know what role Mr. Colangelo played in that investigation that took place when they took it away from the Federal Election Commission, did that investigation, and then he later left the office to go prosecute this at the state level.
Well, we're going to find that out on July 12th when Mr. Colangelo will be sitting in your seat, Mr. Bragg will be sitting in Ms. Foley's seat, and we'll get a chance to ask him. Ms. Foley, Mrs. Foley, excuse me, the Democrats talk about, jury of his peers. Okay, fine, that's how our system works. But if President Trump didn't learn what the unspecified crime was until the jury got the instructions from the judge, that sort of changes the dynamic a little bit, doesn't it?
Yeah, it's not blaming the jury. I mean,
of course.
The jury, has to operate according to the instructions provided by the judge. The poison here, the poison pill, are the jury instructions themselves, which provided the notice, but it came too late for purposes of due process. So yeah, I mean, you can't correct that through a bad set of jury instructions. If there's a due process defect because he learned too late, you have to redo the trial. You have to reverse the conviction, and then the prosecutor has to decide if they want to. Yeah.
Oh, I was an economics major. I majored focused on wrestling, but you had to get a degree. I got one in economics, and they talk about this opportunity cost. If you don't know what the issue is, you miss the opportunity to maybe focus in on the issue as the defense counsel, right?
Yeah.
That's kind of important, particularly when you're talking about what kind of sentence they may try to impose on the president on July 11th. That's kind of important, right?
It's kind of important, and I would suggest that any member of this committee who faced similarly amorphous charges or a loved one would be absolutely incensed by facing these kinds of charges, where it was a moving target.
You're not the only constitutional scholar who's raised this concern, this, I think, huge concern. Mr. Dershowitz, Mr. Turley, other esteemed constitutional scholars have said the same thing.
I'm in good company. I think there's a general consensus that there are some due process problems here.
You sure are. Mr. Attorney General, July 15, 2021, Alvin Bragg. I'm the candidate in the race who has the experience with Donald Trump, and I think it'd be hard to argue with the fact that that'd be the most important, most high-profile case, and I've seen him up front and seen the lawlessness that he could do. That's what he said as a candidate. Does that fit with kind of the ethics of someone who's a member of the bar and running for a district attorney's position? Is that how you're supposed to conduct yourself in a campaign?
Absolutely not. That abhorrent statement is an incurable impropriety that should have disqualified Alvin Bragg from prosecuting that case.
Yeah. Not to mention, then when he gets the job, he looks at the facts, looks at all the evidence, and he concludes, like, this case, I shouldn't prosecute it. I should do what the Federal Elections Commission did, not prosecute. What the Southern District of New York did, not prosecute. What my predecessor, Cy Vance, did, not prosecute. That's what he wanted to do until the political pressure came. They talk about us all the time, pressure. Came from the left. Mark Pomerantz left his job, volunteered, goes and becomes an assistant district attorney to go after President Trump. And then when Alvin Bragg gets there and looks at how crazy the case is, Michael Cohen's going to be their star witness, he goes, this is crazy. I'm not doing it. I'm not that crazy. But then they leak, Pomerantz resigns, leaks the letter, and all the left goes crazy. And Alvin Bragg says, now I'm going to do what I said during the campaign, even though I know it's wrong. And that's what happened. And then they got a judge who went along with all the crazy things Ms. Foley's pointed out. That's the story, and that story is consistent with the facts. That's why we're here today, and that's why we look forward to Mr. Bragg, Mr. Colangelo sitting right where you're at so they can answer our questions.
Chairman, I have a UC request.
Gentleman state his request.
Mr. Chairman, I ask for unanimous consent to enter into the record a letter from the Department of Justice confirming that it had no role in the Manhattan trial.
Without objection. Chair now recognizes the gentleman from Georgia for 5 minutes.
Thank you, Mr. Chairman. MAGA Republicans are trying to make the American people believe a false narrative, that being that Alvin Bragg, a state prosecutor, was somehow manipulated by federal officials, Biden officials, Justice Department, to prosecute and persecute Donald Trump. And the fact that this committee, the Judiciary Committee, is trying to get Americans to buy into this false narrative is concerning. Wouldn't you say so, Mr. Eisen?
It's deeply concerning. It undermines Americans' faith in the rule of law, in the Department of Justice, which has been quite independent from President Biden, and it's baseless. There's no evidence for it. It's debunked. It's a conspiracy theory. The ranking member just entered the proof into the record submitted by the Department of Justice. More proof. It's wrong.
So how does this kind of federal placing of the thumb on a state institution, the judiciary, the rule of law, the prosecution, the justice system of a state, how does it come across to state and local officials when the federal Congress, when the Judiciary Committee of the United States Congress, the House of Representatives, is trying to bully them? What impact does that have?
It doesn't come across well. Fortunately, D.A. Bragg, as he said he would during his campaign, he stated that he had, I don't know where this investigation will go. I don't want to prejudge it. He maintained independence. I was there in court every day. There were no federal prosecutors there calling the shots. They were strictly independent. But it requires that courage and integrity. The pressure is felt on the part of state and local actors. Not all of them may show that same independence, and they may knuckle under and not investigate. And with Donald Trump promising to be a dictator starting on day one, that means to attack the rule of law. We need our state institutions to be stronger. That's the American idea of federalism, not to intimidate, threaten, or put the thumb on their scales.
And so when you talk about intimidating and threatening behavior by bullies, how does this translate into physical threats or the possibility thereof?
Just look at the submissions that the DA made or other prosecutors have made in response to this disinformation campaign, these attacks led by the former president. It opens the floodgates. Mr. Johnson, I don't need to tell you, like the "will be wild" tweet opened the floodgates of January 6th. It is a clear and present danger to American democracy.
When it comes to state prosecutions, which depend on jurors, like the 12 brave jurors in the case in New York, how do efforts like these that we're going through today affect states' abilities to procure juries and jurors to handle or to serve on cases in those jurisdictions?
It creates a challenge. I was there also for the voir dire, the jury selection in the Manhattan election interference and cover-up trial, and you had to get hundreds and hundreds of jurors. Half of them chose not to serve, in part because, right from the get-go, in part because of this climate of intimidation. Several who were selected felt they couldn't do it. I do salute the jury, though, and the judge, and I will say the lawyers on both sides, because they ran a courtroom together where those 12 jurors were able freely and fairly to weigh the evidence, apply the law to the facts, and find Donald Trump guilty without fear or favor.
And not one of those jurors has chosen to speak out, whereas you've had jurors in the Hunter Biden case who decided that case speak out. Why is that?
They're very smart. It was one of the, I do juries for a living, and it was one of the most attentive, smartest, engaged, plugged-in juries. And I think it's smart that they're not stepping forward because of this climate of threats and harassment. Imagine if the former president were to recover the powers of the Oval Office and the federal government, or if he could subvert his DOJ as he sought to do, turning them on the legitimate election results of 2020, the level of intimidation that our state and local prosecutors and our jurors, everybody involved in the justice
the gentleman has expired. The gentleman yields back.
My
Gentleman from
apologies.
Wisconsin is recognized.
Thank you, Mr. Chairman. Mr. Eisen, I just want to make sure you answered the ranking member, I think, and I want to make sure I heard it correctly, that you said President Trump's interference in the 2016 election.
Correct.
Is that correct?
That's correct.
That he interfered in the 2016 election?
Yes, sir.
And real quickly, how so?
The jury unanimously found in the Manhattan case that former President Trump had committed 34 felony violations of document falsification.
You weren't referring to anything else?
No, that's not true. That's disinformation, sir.
Yeah, okay.
In order to find that, they were charged with election interference. The underlying crime that made that a felony, not a misdemeanor, was election interference. Same pattern as 2020.
So it's all about election interference in 2016 also.
Guy who's sitting at the table.
Ms. Foley. So we heard from the gentleman that's to your right that he said that the DOJ should be viewed as above reproach because, look, they prosecuted the president's son. A year ago, weren't they cutting a sweetheart deal? Do you recall the details of that?
Yeah, I mean, they were basically just going to let him walk for all of them. They already allowed statutes of limitations to expire on multiple of the more serious felony.
So how did that happen that we actually may get justice in that case?
Well, I mean, look.
Wasn't it the judge that
you know,
threw out the sweetheart deal?
Yeah, I mean, you had a judge in Delaware that threw out the sweetheart deal, yeah. And then, you know, I guess there was egg on the Biden administration's face, so they felt like they had to do something, so they pursued these current charges, the gun charges and the tax charges. But, you know, I mean, did they reach the right result? I assume so. I didn't follow that trial very much. I think there'll be an interesting question as to whether the president commutes his son's sentence, so we'll see.
Which is, yeah. So, also the gentleman next to you referred to under questioning, he said this trial and jury was scrupulously fair. It was outstanding. There was nothing unusual. Care to comment on that?
Well, again, I mean,
you could start with nothing
I'm not
unusual.
blaming the jury here. I think the poison came from the behavior of the prosecutors hiding the ball, and then Judge Merchan giving sort of a cafeteria-style approach where non-unanimity was allowed on the underlying means by which the New York election law was violated. I think those are clear due process violations. So it's not the jury's fault. They just had, you know, junk to work with, so to speak. I was going to use another word, but I probably shouldn't.
It's almost enough to shock the conscience, huh?
It's almost enough. Yeah, it shocks mine. I don't know about yours, but.
I believe it's correct, and I can be corrected on this if I'm wrong, but I believe the judge contributed to President Biden, the judge in this case. Is that common for a case that has a real nexus that the judge would contribute and then not recuse?
I've never seen a case like that. I mean, usually a lawyer feels pretty confident if he finds out that the judge has overtly, you know, expressed preference for one party or another, and political contributions to the Biden administration would seem to fit that bill, given the political overtones of this case, right? This was not an ordinary state prosecution. This was a state prosecution that, if successful, even though it had been turned down at every other level to even proceed as a prosecution, if it proved successful, it would basically interfere with the 2024 presidential election. and possibly that interference could not be remedied, could not be rectified until after the election. So it's slam dunk 2024 election interference.
It's almost reminiscent of Jack Smith and Governor McDonnell in Virginia, isn't it?
Right. And he got his, you know what, handed to him by the Supreme Court on that one.
I want to get a question into Attorney General Bailey here. Talk about the overall chilling effect in regards to this. In fact, I believe it was Governor Hochul after this charge happened, went on media in New York and said, hey, don't worry, this isn't going, we're not coming after the rest of you business people. This is just Donald Trump. Talk about the impact of something like this for the long run in the rule of law.
The Constitution is our national identity. Those rights codified therein come from God, not man, and the document is intended to protect us from the government. And yet what we see time and time again is the government being weaponized against individuals. It's President Trump today. Who will it be tomorrow? And that's the problem. I think that when you look at the due process issues contained in the charging document, ultimately in the jury instructions, and you look at the inchoate nature of the offenses with these ill-defined levels of attenuation, it's as if invisible links of chain are necessary to connect the facts to criminal liability. And it causes the jury to turn into a roving commission, free to pursue whatever facts they want to attach liability as they please. And the issue there is it undermines the rule of law for the rest of us. Who can have confidence that we know what is and isn't illegal behavior when the court and the prosecutor impanel a roving commission to attack a political opponent?
I yield back, Mr. Chairman.
Gentleman yields back. The gentleman from California is recognized.
I want to begin by quoting the jury in the Manhattan hush money payment trial. Guilty.
Oh, shit.
Guilty. 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 This was what the jury pronounced unanimously on every count. My Republican colleagues don't really contest Donald Trump's guilt. This is the fascinating thing. Their argument is essentially he should never have been prosecuted, or they falsely claim it was a political prosecution, or they falsely claim it should have been a misdemeanor, not a felony. But they don't contest, not really, that Donald Trump was making hush money payments to a porn star to hide their affair from voters. What they're really saying is they're more than comfortable nominating and electing as the President of the United States someone making hush money payments to a porn star. The party formerly of the moral majority is now, I suppose, hoping to fashion some kind of immoral majority to reinstate Donald Trump as president. The presidency, the most powerful office in the world, and not the most powerful because of the size of our military, but because of the power of our ideas. And what is the animating idea of a Trump presidency? It is dictatorship. It is power at all costs. And this is also tragically the animating idea of the Republicans on this committee. Power at all costs. What else can explain what it would profit them to give up their political soul but a world of power? Ambassador Eisen, I want to ask historian Eisen a question. Is there any period of our history that sheds light on what we're going through today? Have we ever seen one party or the other so completely abandon oath to the Constitution, commitment to truth, commitment to decency, so willing to tear down the rule of law, our institutions, our justice system, anything that gets in the way of power? Have we ever seen anything like this?
Three periods come to mind, Mr. Schiff. The first is the founding period, and in particular, the ferment between the Articles of Confederation and the Constitution, when the founders and the framers, famously the Federalist Papers, a passage you know well, worried about that in that period of instability, a tyrant would arise. That was resolved by one of the fortunate accidents, not just in American history, but I dare say in the history of the world, George Washington's establishing the tradition of peaceful transition that Donald Trump ultimately broke for the first time in our history. Number two, the Civil War period, when we had those within who also proclaimed that they would not accept American rule of law. And that period of divisiveness is also found in the post-Civil War era, the decline of Reconstruction, that assault on our constitutional system that became the Jim Crow era. Those are three precedents. We've seen other dangers, including here in Congress, the period of McCarthyism. Donald Trump represents the most grave danger to this country, at least since the end of Jim Crow, very likely since the commencement of the Civil War, and perhaps since the founding of our nation from within.
Thank you, Ambassador. Mr. Chairman, I'll yield back.
Gentleman yields back. Gentleman from Kentucky is recognized.
Thank you, Chairman Jordan. This is amazing construction of some kind of crime here, but when we dig down to the bottom of it and try to find out what the underlying crime is, I don't think that's been discussed enough, or what the supposed underlying crime is. One of the propositions was that hush money should be reported as a campaign finance expense. Okay, if somebody pays their attorney to seal divorce records because they may be going to run for office or they are running for office, Mr. Traynor, is that a campaign finance expense? Is that something you see on campaign finance reports?
That is not. It is something that you would see, legal fees are often reported, and it has been the tradition at the commission in looking at those legal fees that we don't question what the attorney-client privilege between the candidates and the lawyer are of what's needed in those particular circumstances.
So let me use another example. In 1999, Bill and Hillary Clinton bought a house in New York, obviously influenced the election of the Senate race there in New York because they moved into the House so that she could run for Senate. Is that a campaign finance expense? Is everything that could influence a campaign finance expense?
Well, under Mr. Bragg's interpretation, it would be, but under normal campaign finance law, it would not be. There are distinct similarities here between the John Edwards prosecution in 2008, where he paid over $1 million to his mistress to keep her quiet, and was prosecuted by the Department of Justice for that, and was ultimately acquitted on one count and had a mistrial on all 5 counts. Because the jury was given a correct charge as to what the federal law was. In this particular case, the jury was given an incorrect jury charge as to what the law is, and they come out with a completely opposite ruling.
I asked my campaign finance treasurer if I could pay my wife $10,000, she's got more dirt on me than anybody else, and then report that as a campaign finance expense. And he's very fastidious. He manages the finances of at least a dozen different campaigns. And he looked at me like I was crazy. Yet, isn't that sort of the same theory that Alvin Bragg had here? That something like that could be reported as a campaign finance expense?
It's very similar to what's happened here.
So, Congress has paid over $17 million in hush money for sexual misconduct inside of the offices in these buildings. And what's more is that was taxpayer money, right? The allegation is that President Trump paid $130,000 of his own money, but here in Congress there may be some on this dais. I mean, I'm for turning loose all of these records. Who in here has had the taxpayer pay for their sexual misconduct charges the hush money? I bet there's some over there. There may be some over here. I don't know, but I do know it's taxpayer money, and I do know not a single penny of it has been turned in as a campaign finance expense. Is the FEC going to investigate the $17 million that the Congress has paid to settle, behind closed doors these sexual misconduct allegations?
Congressman, if a complaint were to come to us about it, I'm sure it would be thoroughly investigated.
I might file one because it seems like anybody could do this. But let me just ask this: is this verdict going to be vacated, Attorney General Bailey? What do you think?
It absolutely should be.
On what grounds?
Numerous grounds. I think the 5 grounds I laid out in my opening statement provide sufficient justification to undermine the credibility of the conviction. I think there are additional grounds as well, but I think that the constitutional violations, the due process violation, the jury unanimity, Sixth Amendment problem alone, the gag order is violative of the First Amendment. I mean, the prosecutorial misconduct, the conviction is replete with legal error.
Ms. Foley, do you think this is going to be vacated, this verdict?
I do, and I think eventually it's going to be reversed based on legal grounds rather than mixed questions of fact and law. So some of the evidentiary issues, some of the bias issues, I think they're more difficult to win on appeal because the appellate courts owe deference on these evidentiary determinations of trial judges. Bias is very difficult to win on appeal because the judge has so much latitude in deciding whether to recuse himself. That's why the due process errors are so critical here, because obviously due process errors are questions of law. They get de novo standard of appellate review. The appellate courts owe absolutely no deference whatsoever.
So the irony here is this is going to be vacated, and this trial was all about trying to influence an election, using the process as the punishment. Mr. Chairman, I'd like to submit for the record 3 documents. One is entitled FEC Drops Investigation into Trump Hush Payments. This is from 3 years ago. I'd like to introduce a document. Congress has paid $17 million in sexual misconduct and discrimination settlements. This was in Axios in 2017. And my third and final document I'd like to introduce is from CNN. Congress paid out $17 million in settlements. Here's why we know so little about that money. Thank you. I yield back.
The state of New York, their state legislature routinely pays out.
Just a show of hands for anyone in the room who hung out with a felon today. Hey guys, probably want to get your hands up if you were hanging out with convicted felon Donald Trump. I don't think anyone on our side did, but that's why we're here. Ambassador Eisen, what city did Donald Trump commit his crimes in?
In New York City, Mr.
Where were the jurors drawn from for Donald Trump's trial?
From Manhattan.
Did defendant Trump have a say in picking his jury?
I was there for it. There was a vigorous voir dire. His defense counsel were extremely active and I thought effective.
And after that jury of his peers, his neighbors, deliberated, they had to make 34 decisions. 12 jurors, 34 decisions. What did they say?
They decided 34 times that Donald Trump falsified documents to cover up his 2016 criminal election interference scheme.
408 straight times they said the word guilty. Now let's transfer or fast forward to another trial that took place recently. The president's son, Hunter Biden, he tried to plead, was not able to do that. He was found guilty, and actually I heard your side in Fox News celebrating the verdict, celebrating the idea that a jury of his peers found him guilty. So again, when it hurts their guy, it's a rigged jury. When it hurts the president's son, we celebrate the jury. I want to talk a little bit about judicial bias, because they've suggested that there's a bias that occurred in this case. Ambassador Eisen, in Donald Trump's other case, where he's alleged to have stolen national security secrets, who appointed the judge to the bench in the Southern Florida federal case?
Unlike the special counsel in the Hunter Biden prosecution, who is a Trump holdover, David Weiss, That was a last minute, referring back to our history, midnight appointment, you can call it, by Donald Trump of Judge Eileen Cannon.
Are you kidding me? Donald Trump is complaining about bias in his case, and he's on trial for stealing national security documents with a judge that he appointed? Well, that's interesting. I didn't hear any of you all talking about that. Well, let's talk about the Supreme Court, who's deciding whether he has absolute immunity and can send the Navy SEALs to kill any of his opponents, as he alleges in his arguments that he can do. One judge is flying an insurrection flag in solidarity with the insurrection on January 6th that tried to overturn Donald Trump's loss in the 2020 election. Another judge's wife was at the president's speech on January 6th, right before the insurrection occurred. But Ambassador Eisen, I want to talk about, now that he's a convicted felon, declared 408 times guilty by his neighbors, are convicted felons allowed to hold a security clearance?
No.
Are convicted felons allowed to serve in the military?
No.
Are convicted felons allowed to visit most countries?
There's a long list of countries they cannot visit.
And typically, the terms of probation for a convicted felon, do they allow you to hang out with other felons?
That's prohibited. There are other prohibitions, such as gun ownership.
That's probably going to be a problem if your friends are criminals like Paul Manafort, who was Donald Trump's former campaign manager, vice chairman of the campaign, Rick Gates, aide to the campaign.
This is wild.
And convicted felon Roger Stone, former White House aide, also convicted, Peter Navarro, Steve Bannon, also a convict, on his way to jail soon.
We're the most jailing country
Former National
in the
Security
world.
Advisor, also a convict, Michael Flynn,
So this,
and
you know,
his accountant,
whatever. Most
Alan
guys
Wasserman,
pull them on the street.
currently in custody right now. But
They
this
don't
is the
realize
person
they jailed all of us
who
before.
you all chose to hang out with this morning, delaying the original start time of our hearing
that's why.
because rather than getting work done for people who need us to work, you chose a felon over helping families. We're going to flip that, and we're going to choose families over felons, and I yield back.
Gentleman yields back. Gentleman from Kentucky.
Mr. Chairman, I have a unanimous consent request. I ask unanimous consent to submit for the record an article in Open Secrets that says that Ambassador Eisen bundled between $200,000 and $500,000 to the Obama campaign. Sounds like he's an ambassador, not an ambassador. So,
Without objection. Gentleman from Texas is recognized for 5 minutes.
Thank the chairman.
He's mad dogging.
Ambassador Eisen, a quick question. Is the Biden campaign guilty of interference in the 2020 election?
No.
Did President Biden say repeatedly, and did the Biden administration repeatedly declare the Hunter Biden laptop Russian disinformation?
I am not an authority on the statements or on the laptop.
I mean,
Mr.
come
Roy.
on. Was that not repeatedly stated by the President of the United States and the President's campaign? For example, did President Biden not say in a debate, look, there are 50 former national intelligence folks who said that what he's accusing me of is a Russian plan. They have said this has all the characteristics. 5 former heads of the CIA, both parties, said what he's saying is a bunch of garbage. Nobody believes it except him and his good friend Rudy Giuliani, and they go through and talk about it. Was that not a central feature of the campaign in 2020 by President Biden?
I do think it's very important to distinguish between the vigorous debate that we've seen here today, extremely vigorous, and a violation of
Was Hunter Biden convicted this week based on evidence obtained in that laptop?
In part, yes.
Yes. Hunter Biden was convicted this week in information that was brought out from that laptop, which President Biden and his campaign repeatedly referred to as disinformation in the 2020 campaign. So the former president is or is not guilty, or is not, engaged in activity that could be described as election interference.
There's a difference between falsifying documents to cover up and
okay, well, let's talk
to
about
interfere
that.
with an election by, if I may finish my sentence.
No, it's just my time.
There is
let
a
me
difference
let me ask
between
you this.
breaking the law and political debate.
Okay, so let me ask you this question. What is the first date of a crime that is alleged to have been committed by President Trump? The actual date of the crime.
The date of the initial crimes were when the conspiracy to interfere with the 2016 election was formed in August 2015 at Trump Tower, when David Pecker, an independent witness, testified that he, Mr. Cohen, and Mr. Trump agreed on a conspiracy to violate New York law.
Was it not the crime that Alvin Bragg alleged first committed was on February 14th, 2017?
That is
the actual crime?
That is when the cover-up occurred. That is a different element of the crime. The conspiracy began August 2015.
The fact of the matter is, and for what? Are NDAs illegal?
When an NDA is used to facilitate an illegal campaign contribution, over $127,000 in excess of the legal limits, yes, it is a means. It is an unlawful means.
As the gentleman from Kentucky just pointed out, the absurdity of that assertion is plain based on what he was just making in his case. But the fact is, you have in February of 2017, well after the 2016 election, the first crime that is even referenced in what the district attorney Bragg was doing. And I would just ask Mr. Schreiner, do you see the problem here in terms of the timing? And then can you add an element here in my last minute on the extent to which the FEC and importantly the Department of Justice, as you alluded to in your testimony, failed to pursue this, or not failed, chose not to pursue this?
Thank you, Congressman. The Department of Justice investigated this very vigorously. In fact, they asked the Federal Election Commission to abate our proceedings for over a year for them to go in and investigate this. They investigated all of the individuals involved in all of the money that was being talked about in this idea that there was some sort of conspiracy. They took to a grand jury and got nothing back from it. The only reason that they ultimately concluded to prosecute Mr. Cohen is because he admitted to a crime in a plea deal. And then they bundled all that back up and shipped it over to the FEC and said, here you go, guys, but your statute of limitations is run. You can't investigate anything either.
See, my time has expired. I yield back.
The gentlelady from North Carolina is recognized for 5 minutes now.
Thank you very much, Mr. Chairman, and thank you to everybody for being here to testify. While my colleagues on the other side of the aisle are leveling claims of a partisan prosecution, I'm from North Carolina, as you just heard. I want to remind the committee that this is not the first time that a former presidential candidate has been indicted for having hush money paid to hide an affair from voters. The last time in my memory that this happened, it was a Democrat who was indicted, and the charges were brought by a Republican federal prosecutor, George Holding, who weeks after filing those charges resigned to run for the same seat in Congress that I now hold. That was in 2011. And federal prosecutors charged John Edwards, a former senator from North Carolina and two-time presidential candidate, for soliciting nearly $1 million from donors, including Bunny Mellon, to keep details of his relationship with his mistress, with whom he had fathered a child, from coming to light. Now, while Edwards' defense team argued that his prosecution was politically motivated, the Obama Justice Department defended the charges, even though they had originated with a Republican prosecutor. arguing that that administration had a duty to prevent candidates for high office from abusing their power to subvert the integrity of democratic elections. Now, as you heard earlier, in 2012, a North Carolina jury found Edwards not guilty of one count of receiving illegal campaign donations and deadlocked on the other charges. Now, I followed the Edwards hush money case, and I also followed the Trump hush money case. I don't know how you couldn't have. And I'm confident that if the prosecutors in the Edwards case had the type of evidence that the prosecutors in the Trump case presented, we would have seen a very different verdict for John Edwards. The evidence that the prosecutors in the Trump case had was the type of evidence that prosecutors dream of finding. A paper trail of emails and bank records, a slate of insider witnesses, and even recordings of Trump himself discussing the payments. So I want to remind my colleagues on the other side of the aisle that these charges against Mr. Trump are not unprecedented or baseless, that the verdict is not, as one of my colleagues on this committee recently claimed, comparable to the injustice against Black Americans during the Jim Crow era. That's disgusting. Most importantly, this was not lawyers with the Manhattan DA's office or the Department of Justice that convicted Trump of these crimes. It was a jury, unanimously, 34 times, and quickly. So, Ambassador Eisen, I'd like to ask you, why is it important for democracy that presidents or presidential candidates, no matter what party they come from, be accountable for their crimes and not be held to be above the law?
Ms. Ross, it's the fundamental American idea. We were speaking earlier of the proud history of our country with all our challenges over the centuries. We overthrew a system and a king, George III, where one man was above the law. In his place, we put the Constitution and the founding American principle: no one is above the law. If Donald Trump, as the jury unanimously found of 12 of his peers, covered up 2016 conduct of a pattern that we saw again in 2020, we see him limbering up for in 2024, then he deserves to be found guilty. If 10,000 other cases, approximately, in New York since 2015 have resulted in prosecutions, he should not be held to a different standard when he falsifies business records to cover up another crime. That's what America is. That is why this verdict was so important.
And again, Ambassador Eisen, do you think that the Obama administration was correct in not interfering in the John Edwards prosecution?
I do. You correctly point out that case relied on the testimony of a former campaign aide, Mr. Young, and his wife, Sherry, weak witnesses, contrary to what we saw in New York, witness after witness, document after document, an overwhelming factual and legal case that will withstand appellate review.
Thank you, and I yield back.
Gentlelady yields back. Gentlelady from Wyoming is recognized for 5 minutes.
Mr. Eisen, what you've just stated is so utterly and completely absurd, it's almost impossible to even respond to it. This case will be reversed on appeal. The level of egregious reversible error that was demonstrated by this judge and by the prosecutors is absolutely off the charts. I've never in my entire career seen anything even close to it. I think you recognize that. I think the vast majority of the American people recognize that. I really want to focus on the equal protection and due process issues that are so clearly evident here. And the fact, Mr. Eisen, that you keep going back to 2016 and what occurred in 2016 is extremely important from that standpoint. Ms. Foley, is there a due process and equal protection aspects to statutes of limitations?
Well, I mean, statute of limitations can be, I guess, evaded, I suppose, in ways that could violate either due process or equal protection?
Well, and in fact, in this kind of a circumstance, that's what you see. We've got a situation where the alleged crime was committed in 2016, and they had to bootstrap it to something that occurred years later to try to resurrect what was really a dead case. And the way that I look at statutes of limitations as someone who practiced law for well over 30 years is that people have memory issues. That's why there's a statute of limitations. Can you remember what you were doing on June 13th, 7 years ago or 4 years ago? I'm sure Mr. Ambassador cannot. There are statute of limitations because trying to drag somebody before a tribunal 5 and 7 and 10 and 12 and 15 years down the road, by its very definition, especially if we're talking about a potential criminal prosecution where someone is going to lose their freedom, do we really want someone getting up and being able to say, 25 years ago, I was attacked in a dressing room, I have no evidence, can't tell you anything about it, don't even know what day of the week it was, don't know what month, don't know what year, but for goodness sakes, we know what happened. So we have the state of New York, and they come in and they pass a law saying, well, we're not gonna have a statute of limitations for this particular crime or this particular individual. Wouldn't that be considered a violation of this gentleman's due process rights?
Yeah, I mean, I think it's part of the overall context, which again kind of shows the political motivation, the uniqueness of this case. I mean, Ambassador Eisen talks about the 10,000 cases. Well, I've read most of those cases too. None of them approach the uniqueness of this case and the obfuscation of the theory here. For example, usually the underlying offense that is intended to be committed is grand larceny, insurance fraud, things like that. Very straightforward facts. But by making the underlying offense here federal New York election law, which itself required proof of unlawful means, which then hinged upon FICA, tax laws, falsification of business records, it just got more and more and more unclear
and
exactly what Mr. Trump was being charged with. So all of these facts suggest that there is a shocks the conscience due process violation here, in addition to the notice problems I've pointed out.
Well, and I think that there's the due process issue, but Mr. Bailey, let's turn to you and let's talk about the equal protection aspect of it. As you've just described, Ms. Foley, this is one case against one man for one purpose. And in fact, the governor of the state of New York has said it. Look, everybody, don't worry, we're not coming after you for these kinds of fraud claims. We're just going after Donald Trump. Isn't that the antithesis of the foundation of our Constitution that is based upon equal protection and equal application of the law? Have you ever seen anything like what they have done to Donald Trump in their effort to destroy who they perceive to be their political enemy? Mr. Bailey.
I have never seen such an egregious assault upon the tenets of equal protection as when government officials in the state of New York claim that they are specifically targeting one individual and will not use the same laws against anyone else. But I want to go back to the due process issue briefly, because everything that's being said here is further amplified by the fact that Section 175.10 of the Code of State of New York, which forms the basis of the 34 charges, has an affirmative defense that requires the defendant to get a preponderance of the evidence. How can he go get his evidence if you bring the claims late? Statute of limitations are intended to prevent sandbagging of claims.
Exactly right. And in this particular circumstance, and what we've seen in the other persecutions against Donald Trump, they absolutely had to violate those basic tenets in order to go after him. It is absolutely an egregious violation of the law. It is a level of constitutional malpractice, the likes of which I've never seen. And Ambassador Eisen, I think that if you were being honest, you would agree with that. With that, I yield back.
Gentlelady yields back. The gentleman from Maryland is recognized.
Thank you, Mr. Chairman. I want to address two sets of things. One is the repeated claim, it's a mantra at this point, about Mr. Bragg vowing to go after President Trump, campaigning on going after President Trump, leaving out all the campaign promises to get Trump. I gotta say that I haven't heard anybody specifically quote anything about it, except the chairman's quote. And I wanted, we've been trying to dig this up and see what the factual basis is for that repeated allegation, because it's very relevant. I mean, the point about some of you have been saying that this is sort of issue number one with respect to proof that this is a political prosecution that was inappropriate. And as I went through all the facts, I kept seeing him say that he wanted to follow the facts. Now the quote that the chairman lifted, I've seen him up front and seen the lawlessness that he could do. Well, that was in the context of the 100 prosecutions that had come through the state attorney general's office. And in one instance is leading to a $2 million settlement against the Trump Corporation for fraud along the lines of the corporate finding that I think is that $470 million that's resulted in. And then there's also the sexual assault finding as well in a separate court. But the point that Bragg was making was that he's dealt with these cases frequently. And he was questioned about this over and over again during the campaign, but he made statements along the lines of these. I believe we have to hold him accountable. I haven't seen all the facts beyond the public, but I've litigated with him, and so I'm prepared to go where the facts take me once I see them and hold him accountable. Another quote during the same interview that the chairman referenced, "You're right, I am being careful, not just because I'm running for office, but because every case still has to be judged by the facts, and I don't know all the facts." Another quote, again, from Mr. Bragg in a different interview, "I will hold him accountable by following the facts where they go." Over and over again, he said that he would follow the facts and follow the law in reaching his decision about making a determination to prosecute or not. Another interview after that, this was asking about whether he had the ability to prosecute these cases, which is where he referenced his prior experience dealing with Mr. Trump and his corporations. But he said, but without talking about, what we don't know, which is where this is headed, the facts that aren't in the public domain. The questioner followed up, "You can't talk about that?" Bragg responded, "I can't talk about that." He said over and over and over again that he wanted to follow the facts and that he hadn't reached a conclusion about where he was going to go. He did reference the previous cases against Mr. Trump and their legion and the subsequent cases as well. But I think over and over again, he made it clear that he had not made a decision about whether to prosecute or not, and he hadn't predetermined what he was going to do. Real quickly, I'm running out of time, but Professor Foley, you raised the issue of the defense being blindsided, essentially, by not knowing what the legal theory of the case was. And in your testimony, written and that you stated today, you quoted the response and the people's response to the Bill of Particulars, number 2. But you left out a key part of the quote. And so when I took a look at it, after Ambassador Eisen referenced it, we got a copy of it. You quoted page 5. I flipped over to page 6, and it lays out bullet points about the specifics of what's going to be pursued, and they're bringing it to the attention of the defense. An agreement to unlawfully suppress negative stories about the defendant before an election in order to influence the outcome of the election. Multiple false statements in the business records. I'll skip down. Disguising reimbursement payments by doubling them and falsely characterizing them as income for tax reasons. Now, you also stated that the first time that they knew the theory of the case was when jury instructions were read. And so I looked at your testimony where you quote the jury instructions. And guess what? It mentions all of the same things that were referenced in the bullet points. Election, the law was violated. Federal election law, which is number 2. Falsification of other business records. 3, violation of tax laws. Ambassador, we're running out of time, but I guess I was a little surprised based on your testimony when you said that they hadn't given any indication of where they were going to go beyond broad references to federal election law, tax law, and the like, when the specific bullet points in the Bill of Particulars response were the same as the ones that are referenced in the jury instructions according to your written testimony. I see my time's expired. I yield back to the chair.
Gentleman yields back. Gentlelady from Indiana is recognized.
Thank you, Mr. Chairman. I think Ambassador Eisen was referring to the importance of a vibrant rule of law for democracy. We actually have constitutional republic, not pure democracy, to survive. But interestingly enough, when talking about intimidation, threatening, and disinformation, I would say, I'm not an attorney. I'm actually a CPA and been involved with finances for a very long time. And I think a lot of Americans should be intimidated and worried if they pay bill to attorney and put it legal expense, and they can have 34 felony counts for that. That is true intimidation. That is what the law is, so that would make anyone very nervous, But, just talking about 2016, I think, Ambassador, you made statements about interference in election. What do you think, from your perspective, to have Department of Justice under President Obama at that time, and you're probably very familiar with Durham report, rushing through closing the case for Hillary Clinton without doing any proper investigation, and then rushing through to have Russian collusion hoax against Trump without even vetting any of the information, and it turned out to be all lies, right? We have a report on that. So do you think, from your perspective, and then colluding to cover up with medias like Politico and other one to cover up the story, isn't it seem like that could be looking like interference in election in 2016?
No, Ms. Spartz, I don't believe that. There was ample evidence to predicate that investigation, including the polling data that was passed from Trump campaign manager Paul Manafort to Konstantin Kilimnik.
No, I'm talking about the report. So you think the special prosecutor did not do a good job and he lied in the report? I mean, he actually concluded in his report that FBI didn't do its job, and it was outrageous. He was outraged what's happened in FBI.
He did
Well, it seems strange, but let's go further. The same situation with Hunter Biden in 2020. The same media, political reporters, have the story that, that actually was 50 security, this national security firm advisors, a printed story that Hunter Biden laptop doesn't exist, and give likes to that story, and all media go that, and he's talking a debate, and this is all former, Department of Justice, employees. And then it's going to, in the election, President, Biden as a candidate at the time using it, to cover up and say, oh, it doesn't exist. We know it exists. Doesn't it look strange to you?
The Biden Department of Justice empowered a Trump holdover U.S. Attorney David Weiss to prosecute Hunter using the laptop. It's the exact opposite. It's an affirmation of the way the rule of law works.
In 2020, doesn't it look strange that that's appeared during election and they have disinformation campaign? The same political reporters are doing again. Doesn't it seem like awfully strange to you? Doesn't it seem like, and it's not interference at all. But I'm not going to probably get an answer because you do have a double standard, and we do have a double standard. And our system of justice is broken. And that's why Americans are intimidated and they're worried about not existing of the rule of law, because we have a rule of law, that working, to protect now, the Department of Justice to protect people that they like. This is a political prosecution. And I'm not going to detail it with the case, but it would be intimidated for Americans, and it would be very oppressive and tyrannical. And I couldn't believe, as an American who grew up in tyrannical country, that we would be sitting here and the system of media collusion with our justice system. I think that is very, very sad, and I'm very disappointed that you cannot tell the truth here. I yield back.
Would the gentlelady yield?
I yield. I yield
appreciate
too.
Ms. Foley, Mr. Ivey basically said what you told the committee about the jury instructions. He disagreed with that strongly, but was going to let Mr. Eisen answer for you. So I want you to be able to answer for yourself.
Well, thank you. I appreciate that. Yeah, I mean, that's sort of the bait and switch that was going on here. The stuff that he talked about on the prosecutor's response was a response, and then he flipped the page and saw some of the detail. But that's all a response that talks about the first predicate, which makes the falsification of business records a felony offense. All of that information is about this first predicate. But the interesting thing is that all of that detail on the page that he flipped ended up having nothing to do with the first predicate, but the second predicate, which was the basis for the New York election law offense. So all of that detail was useless because all of that detail was about this and not this. In fact, we didn't even know this was necessary until the judge instructed the jury about this New York election law.
That's the point.
Right.
That's the point. Gentlelady yields back. The gentlelady from Pennsylvania is recognized.
Thank you, Mr. Chairman. Thank you to all of our witnesses for being here today. It is interesting being here, I will say that, 62 minutes late, starting what is a faux hearing about the New York DA.
The gentlelady just, I apologize. I don't like, I think the Attorney General has to leave.
Yes, thank you, Mr.
Are you going to pose any questions to the Attorney General?
I don't think so, Mr. Bailey.
Yeah, we'll pause her time. Certainly give her all her time. I've been giving her your full 5 minutes back, so you can. But we thank you for being here. And I should have pointed out earlier, we've been at this a while. If anyone needs a break, just obviously let us know. I apologize to the gentlelady from Pennsylvania. You get your full 5 minutes again.
Thanks, Chairman. And thank you, Mr. Bailey, for your participation today. Here we are. Mr. Eisen, I think I'm going to start with you. Before I came to Congress, and you might know this about me because you and I had the chance to work together on impeachment 1. As you remember, part of a phone call where then President Trump said to a brand new President Zelensky, "I'll need you to do me a favor, though." I had the privilege of working with you then. I was a teacher before I got here. I know I've told you that many times, and I told my students, you need to convey your thoughts with clarity, with integrity, with honesty, with the facts, not misinformation or disinformation. But we've heard so many outlandish claims in this committee and all over the Hill, sadly, in service of one man. So I'm going to, if you permit me, and I'm going to give you some time, I know there's some things you want to address, but if you permit me, I'm going back to my old professor days, not that I did this, a little pop quiz. Help me correct the record if you don't mind. Here we go. And it is about the claims around our institutions. Number 1, Donald Trump, referring to the 2016 presidential election, claimed, quote, "I won the popular vote if you deduct the millions of people who voted illegally," end quote. Mr. Eisen, Ambassador Eisen, was that statement that millions of people voted illegally in the 2016 presidential election true or false?
Like 30,000, over 30,000 other statements that the former president has made, false.
Thank you. Donald Trump in 2019, referring to the free press, claimed, quote, "Truly they are the enemy of the people." Ambassador Eisen, is the press the enemy of the people, true or false?
Under the First Amendment of the Constitution and the proudest traditions, the Fourth Estate is the pillar of American people, the friend of the American experiment. False.
In November and December of 2020, Mr. Trump claimed, "I won this election by a lot," all caps, "and this fake election can no longer stand." Ambassador Eisen, did Trump win the 2020 election?
He lost fair and square, and the big lie that he won is one of the most heinous and dangerous falsehoods in our history as a nation.
That's actually at the crux of this. I was going to make that extra credit. It wasn't a fake election. But
50 intelligence
without being
agents
flip, you said it
falsifying a
much
letter.
more eloquently.
It's a
Number
soft coup.
5, Marjorie Taylor Greene, referring to the search at Mar-a-Lago, claimed the Biden DOJ and FBI were planning to assassinate Pres Trump and gave the green light. True or false, Ambassador?
False. It is they were referring to a standard term of search warrants that you can also find in the search of President Biden's premises.
Strange. Thank you for that clarity. Number 6, Chairman Jordan claimed District Attorney Alvin Bragg's criminal case against Donald Trump was a politically motivated prosecution. Ambassador Eisen, true or false?
It was, as we say in the legal profession, a righteous case, and the appeals will prove that. And I have the receipts here with me to prove it.
Number 7, Mr. Gates claimed Attorney General Garland dispatched Matthew Colangelo to prosecute Mr. Trump. Ambassador Eisen, is that true?
The AG this week issued a letter, it's now in the record, definitively debunking that conspiracy theory. It's outlandish and false.
And in the time I have remaining, I'd like to ask you, something I've been fighting here on this committee, what now feels like the entire 5.5 years I've been on this committee, is the disinformation in service to one. in service to one who is now a convicted felon. It is so dangerous, and yet we hear from the other side of the aisle tearing down a faith in our institutions, whether it's our electoral system, the Department of Justice, the FBI. Some on this committee would like to defund FBI and ATF. And they decry the fact that Americans' faith in our institutions is at the lowest low, as they make sure that is the reality. What comments do you have about the danger of the disinformation and misinformation now?
We are in a disinformation and a mis and malinformation epidemic. I testified about it in my last visit before the committee. And I do have to point out one piece of incorrect information that we heard today, that this theory of the case was never put before Donald Trump until the closing of the jury. I have here, not only do we have the response to Bill of Particulars, I have the opposition to the motion to dismiss November 9th, 2023, putting forth, may I have the middle Russian doll, please?
This one?
Here it is. Look at the document. The Russian doll is in the document.
Not true.
Here it is, page 25, please. These actions violate Elections Law 17-152, conspire to promote the election of a person to public office by unlawful means, including FICA, the falsifying the records of other New York enterprises, and mischaracterizing the nature of the repayment for tax purposes.
Introduce documents into the record.
May I?
But I would,
I didn't
I'm
ask
sorry.
to introduce it.
The gentlelady.
May I return the Russian doll?
I have unanimous consent.
Gentlewoman's recognized for unanimous
I
consent.
thank you, Mr. Chairman, and thank you, Mr. Eisen, for the demonstration. Unanimous consent, please, for, this is an article, ABC News, a timeline of Donald Trump's election denial claims which Republican politicians increasingly embrace. ABC News.
Without objection.
Thank you.
Mr. Chair,
Recognize the gentlelady from Vermont.
I ask unanimous consent to enter into the record people's response to defendant Donald J. Trump's April 27th request for a bill of particulars.
Without objection. Now recognize the gentleman from Oregon for 5 minutes.
Thank you, Mr. Chair. Professor Foley, you want to respond to the rant we just heard?
Yeah, if I may have this back. Okay, so this opposition to the motion to dismiss, also he gives one page out of context. That paragraph that he was pointing to, these actions also violated election law section 17.152. In other words, it's just regurgitating exactly what they said in response to the requested bill of particulars, that the underlying offense, the first predicate, could be one of 4 different statutes, all of which are very, very different and do not provide adequate notice to a defendant, because this is an element of the crime. You have to be specific about elements of the crime. That's what the court said in Shad.
So if I may, thank you for that
That's why there's a due process problem.
And to your point, the complexities, I think, many times are a nuisance to those who disagree with you, Professor. So thank you for the detail that you share. Also, folks earlier on the other side of the aisle suggest that this hearing is not necessary because it was a state court, and thus this committee, being Congress, shouldn't be saying anything about it. Perhaps you can address that for just a second and explain why, in your opinion, you think the federal government should be concerned about what went on in Alvin Bragg's district.
Well, I mean, look, as the Judiciary Committee, and I assume the Oversight Committee also would have legitimate legislative purposes for looking into abuses of power by state prosecutors to violate anyone's constitutional rights. And that would include, intimidation based on gag orders, First Amendment violations, due process violations, equal protection violations, all the ones we've talked about are ripe for investigation by this committee and others.
And in fact, if we didn't, we'd be derelict in our duty of when we see a former president being drawn into this circumstance, we would have to ask ourselves, come on. So thank you for that. Commissioner Traynor, same question to you. Is there a federal reason for us to be looking at a state action such as we observed in Manhattan?
Unquestionably, there's a reason for this committee to investigate this, and it goes back to my opening statement where I talked about the fact that the Department of Justice did not zealously represent the United States in this particular case to go in and defend the jurisdiction that this Congress has given through FECA to the Federal Election Commission and to the Department of Justice to prosecute those crimes. Instead, they abrogated that to a local official to prosecute.
Right, and the question would be, and quoting the professor from earlier today, to prevent the fractured application of the law, disparate justice, double, triple, quadruple standards. This is what we're trying to avoid by bringing this issue up at this hearing. Is that correct?
Absolutely. You can't have 50 different standards of what violations of federal election law. It would apply to every member of this committee. It would apply to presidents, former presidents. If we're allowed to investigate what goes on in campaign finance spending under the guise of how 50 different states interpret it, we'll never have any equal protection for any individual running for political office.
Right, and you would think that those on the other side of the aisle would recognize the danger of opening this Pandora's box, so to speak. Let me go to another point. Anybody that's tried a case, and I've tried many, recognizes that the jury process is imperfect. It's a great system, but we have this thing called an appellate court because it's known that mistakes will be made. And the idea is once they are, you'll get another shot at it in the appellate court. Yet here we are, we know this is going to be appealed. But we're holding this hearing today. Why is this hearing important when there's an appellate process available? Go with you, Professor Foley, first.
Well, I mean, again, I think you have a responsibility to determine, for example, whether or not, federal funds are being used to further lawfare that is designed to be election interference. I think you have a responsibility to make sure that the civil rights laws, Section 1983, and other federal civil rights statutes are not violated by state prosecutors, especially for purposes of political interference. And, at the end of the day, judicial process, even though there's a trial, judicial process is not due process, right? Otherwise, we'd never have any reversals based on due process. You can have long, elaborate trials with lots of witnesses and lots of documents. They have them in Russia and Venezuela all the time. And they look like trials, they kind of smell like trials, but they're not due process-based trials. And that's the error that occurred here that I think ultimately was going to lead to reversal.
Yield back.
Gentleman yields back. The gentlelady from Texas is recognized for 5 minutes.
Thank you, Mr. Chairman. I'd like to thank our witnesses for being here. It's wonderful to see you, Ambassador Eisen. I want to thank you for your incredible commitment to our country, to the rule of law, to our democracy. I'm very, very grateful for your voice. This committee is so important, as you know, and there are so many critical issues that our nation is looking to us to address. But week after week after week, this committee is unfortunately focused on things that don't matter to the everyday American, going after various Biden administration officials, going after the president himself, attacking border communities, et cetera, you name it. I look forward to the day that this committee actually produces good work that the American people expect us to address. This hearing didn't even start on time, and I apologize for the incredible delay, but my Republican colleagues had to go bend the knee and make sure that they provided homage to the person that controls the House of Representatives. Anyhow, I'd like to debunk some of what we've heard, and I have some questions for you. But before I ask these questions, is there anything that you've heard today that you would like to address? It's been just a cascade of bizarreness, but would love to give you the opportunity to respond.
When my friend, Professor Foley, whose work is thoughtful, in an excess, I hope, of enthusiasm, was being questioned by Mr. McClintock and suggested that warfare should be waged in retaliation. And Mr. McClintock, to his credit, said, "No! It gives me hope, Miss Escobar. This was a legitimate case. Any other American who did what Donald Trump did would be prosecuted and convicted. We saw that it's false. It's false that these issues were raised in the jury for the first time. It's normal. I've been a criminal law practitioner, expert for over 3 decades. It's normal to have alternative prosecution theories. Every complex case I've ever had them. Many had far more, dozens of counts. Under widely disparate laws, the prosecution here had alternative theories. They chose one. There's nothing untoward about that. That is not going to be reversed on appeal. So I could go on, but I'm eager to hear your questions.
Thank you so much, Ambassador. You know, and before I ask my questions, I'll say one last thing. That there were 2 trials that took place within a span of several weeks. And the difference between how President Biden and Democrats reacted to a guilty verdict in a case against the president's son was remarkably different from what we saw in terms of the reaction by former President Trump, his family, his allies, and acolytes. Democrats are not attacking the institutions that are important to our democracy, but unfortunately, Republicans are. And it's devastating to the future of our democracy. Ambassador Eisen, what do you make of the claim that Trump can appeal his case based on Judge Merchan not recusing himself?
I think my friend, the professor, will agree with me that that is not going to be one of the grounds for reversible error here. I don't think there'll be any grounds for reversible error, but certainly before he ever had the case, he gave a modest $15 exercising his freedom under the First Amendment that we all have. I gave another $20. That 15 was to Joe Biden, another $20 to other political organizations. He asked the judicial authorities. There's a judicial opinion. To his credit, he put it out of his own hands. Advisory Committee on Judicial Ethics, opinion number 2354, May 4th, 2023. No, you don't have to recuse for that when you did it years before you got the case. Good on Judge Merchan to ask. That's the right answer. No reversal there.
Excellent. Thank you, Ambassador. Good to see you. I yield back.
And you.
Gentleman yields back. Gentleman from Wisconsin is recognized.
Thank you, Mr. Chair. Thanks for being here today. And I know we've been kind of going on. I'm trying not to rehash anything that's already been discussed, but Commissioner Traynor, is the Manhattan District Attorney's Office charged with determining whether someone violated the Federal Elections Campaign Act, or FECA?
No, Congressman. That is exclusive jurisdiction of the Federal Election Commission and ultimately could be referred to the Department of Justice if it's found to be criminal.
So certainly not the New York Supreme Court either, state Supreme Court?
Absolutely not.
No. So as you said, it's Federal Elections Commission. Was President Trump's alleged payment via Michael Cohen to Stephanie Clifford referred to the FEC?
We did have several complaints related to it.
And what did the FEC decide with respect to that referral?
Well, ultimately, we deadlocked on a decision related to it, but the real factor in making the determination was the fact that the Department of Justice asked us to abate those proceedings so that they could conduct an over a year-long criminal investigation, which they determined there was no criminality in, and then they sent it back to us, and it was statute of limitations barred.
So did the Justice Department also decline to charge the former president for charges related to FECA?
They did.
Right. And so the 2 agencies that are charged by Congress to determine whether President Trump's payment constituted a violation of FECA found no violation and took no enforcement action. Is that correct?
That is correct.
All right. Thank you very much. Ms. Foley, you argued in a recent Wall Street Journal op-ed that Judge Merchan likely denied President Trump a meaningful opportunity to be heard by denying the testimony of former FEC Chairman Brad Smith. Can you please elaborate a little bit on that?
Yeah, I mean, there's been a lot of sort of misreporting on what happened here. Yes, Judge Mershon, as my colleague, Mr. Eisen, points out, did allow Brad Smith to testify, but the catch was he could not opine at all, either provide his opinion or any personal opinion or legal opinion regarding whether or not President Trump's actions had violated FICA, which was basically, then he was useless, which is why President Trump didn't call him as a witness. So the whole point was President Trump wanted an expert witness to put before the jury to show the jury that what he had done did not, in fact, violate federal election law. And he was denied that opportunity, and that seems like a rather basic thing that he would have the opportunity to be heard on.
Do you think there was a chance that he could have had success upon appeal?
Will he have success on appeal of this? Yeah, sure, absolutely. I mean, the thing is that, you know, again, I agree with Norm on the fact that the bias issues are difficult to win because they get deferential standards of review. But the due process issue is a question of law. It gets de novo review. The appellate courts get to look at it fresh, with fresh eyes, no deference whatsoever. And more importantly, due process issues are issues that the Supreme Court can ultimately grant cert and hear.
Right, so Judge Mershon also ruled that Michael Cohen's guilty plea for violating FICA was inadmissible at trial. Why do you think he made that ruling? I think we know, but...
Well, because you can't basically taint one individual by the guilty conduct of another.
Judge Mershon also ruled that DA Bragg could elicit testimony from Mr. Cohen about his guilty plea to impeach his credibility as a witness. DA Bragg then repeatedly made reference at trial in his office closing arguments to the jury about Cohen's FICA guilty plea. Did repeatedly subjecting the jury to this testimony essentially get around the judge's own ruling that Cohen's FICA guilty plea was inadmissible as substantive evidence?
Yeah, I mean, that should have been reined in. That was clearly trying to, you know, taint one person through association with another who was guilty. They also did the same thing, I believe, with the CFO of Trump Organization. They made similar comments because he also entered a guilty plea. Weisselberg. Yeah.
Thank you. I yield back.
Okay, gentleman yield. Will gentleman yield? I do. Thank you. So I just want to get this straight. The campaign finance expert wasn't allowed to testify about campaign finance.
Yeah, exactly. And, you know, the way Judge Mershon tried to explain it is he said, well, you know, I'm the expert of the law. And, okay, granted, that's why the judge is there. But
Brad Smith wasn't allowed to talk about the very testimony we just got from Commissioner Traynor, in essence.
Precisely.
Right? Well, we're going to give Brad Smith a chance to testify in front of this committee as well. And we're going to let him tell the Congress and the country what he wasn't allowed to tell the court and the jury, because we think that's important. And the gentleman from Wisconsin was right on target when he was asking that question. Now recognize the gentlelady from Vermont.
Thank you, Mr. Chair. Before I start my line of questioning, I just have to make a comment about something one of my colleagues said earlier on the other side of the aisle. There was an implication made that E. Jean Carroll must have had memory problems. She couldn't possibly have remembered what happened to her. And I just am so incredibly shocked by that statement. I can tell you, when someone has been sexually violated, they don't forget who did it. A jury found him liable, him being the former president, for sexually abusing and defaming E. Jean Carroll. Those are the facts. A jury found that. And I just think it's shocking that somebody on this committee would not only attack juries, we are the Judiciary Committee after all, the onslaught against juries on this committee is shocking to me, but also to use time in committee to further defame E. Jean Carroll. So shifting gears here. Part of the Republicans' attempt to absolve former President Trump for his fraud conviction is the claim that former Justice Department official Matthew Colangelo was somehow dispatched to the Manhattan District Attorney's Office to prosecute Trump. And one of my colleagues touched on this briefly, but I want to circle back around. I've heard my colleagues say in this hearing and others that because Mr. Colangelo took a job with the Manhattan DA after working at DOJ, and in that their eyes this was a pay reduction or career step down, that the only conclusion would be that he changed jobs to get Mr. Trump. People on this committee have asked the Attorney General specifically, how is it that a man, Matthew Colangelo, takes a pay cut and takes a cut in just, what is he doing for a living as far as prestige to go and join that case? This part of the theory is very revealing to me. It suggests that a person could never change jobs based on anything other than money or prestige. It seems that some of my colleagues have forgotten that public servants may take other things into account when navigating their career. Ambassador Eisen, thank you so much for being here. And the other witnesses, I should have said at the top, thank you for your time. Are you aware of any evidence that Mr. Colangelo was a mole dispatched by General Garland to the Manhattan DA's office?
No, there's none. The Attorney General has definitively debunked this conspiracy theory with his detailed letter that he sent to the committee. For good measure, when I came to work on committee staff with the ranking member and with the chairman in the first impeachment, I took a substantial pay cut. People are motivated by public service. I hope I was on that instance.
I'm not sure how much you work with me, but you did work with the ranking member.
Mr. Chairman, notwithstanding our differences, I'd like to think that we've maintained a cordial relationship. We see it differently, but we're both trying to do the best for America. Sorry.
That's all right. That's all right.
Miss
It's important
Valent.
to have conversations. So you touched on it, but can you think of some other reasonable explanations for a lawyer taking a job that may not appear to be the next step in their career?
Mr. Colangelo has a long record of public service, including in the nonprofit sector. He had previously worked with Mr. Bragg in the AG's office. When you do have a new DA, he acquired a variety of responsibilities when he entered the DA's office. It's an opportunity because the Manhattan DA is such an important role with New York as an American and global financial center. Another reason these 34 false records convictions matter so much. It was an opportunity to have an impact on the public good. I like to think that those kinds of motivations come into play.
And I think one of the challenges for my constituents home watching the work that we do here, watching the news, they all tell me they're exhausted. They don't want to watch anymore. They don't want to watch the news. They don't want to actually know what we're doing here anymore because it feels like every single time they turn on the news, there is another bit of misinformation, another conspiracy theory, another nesting doll, as it were. And it makes it very difficult to find a way to cut through. And so, once again, there is no evidence of collusion involving Mr. Colangelo. Is that right, Mr. Eisen? Is there any evidence?
I hold an empty bottle. There's the same amount of evidence. None.
I appreciate it. Thank you for your time. I yield back.
Gentlelady is back. Gentleman from New Jersey is recognized.
Thank you, Mr. Chairman. Ambassador Eisen, just a thought, a comment. I know you spoke about the climate of threats, the climate of disinformation. I'm going to maintain that is not the climate that you're speaking about. You just don't want to hear the truth because you don't like it. Congresswoman Lofgren, my colleague, good person, she asked, can a democracy survive without the rule of law? Well, we know the answer, it can't. And that's what makes me sick with what's going on, because we want to speak, and it's been spoken about often here, about what people are thinking, what they're saying. Well, so I'm a little crazy, so we get literally thousands and thousands of calls and letters and emails you can imagine every single week. I pick out a handful and I call people back. Some are Republicans, some are Democrats, some are people that don't care about either. But you know what a lot of folks are telling me? And they're not all hard Republicans. They're telling me they're scared. And the reason they're scared, and by the way, they should be, I don't make them feel good. I don't sugarcoat it. I don't say, no, nothing to worry about, nothing to see here, because they don't believe in equal justice for all, which should be for the left and the right. It should be for Republicans and Democrats. It should be for progressives and libertarians. It should be for conservatives and liberals. Equal justice for all. But that's what is making me sick, because we don't have it now. This is all about politics and money and teaching a lesson. The politics of it. The politics of it is we have a judge who's a known and strong Democrat, not just because of the contributions he made, but for other factors. His daughter alone is a major operative in the Democratic Party, millions of dollars flowing through her hands. I tell you what, you wouldn't like it if it was reversed and you had a judge that didn't recuse himself. We should have judges and prosecutors that are objective and fair, whatever political party you are, whatever persuasion you are. It's about money, because if you follow the money, and politics is about money a lot, we don't like to say it, but if you follow the money here, huge contributions going to the prosecutor, coming from the far left, coming from Democrats, and he runs for office saying that he's going to get Trump. Saying that he's going to get Trump. You may have one speech where he didn't say that. There were plenty of times where he made it clear that he was the guy to make sure to go after Trump. How unobjective can you be? How wrong is that in the American system of jurisprudence? How terrible is that? And you wonder why people are worried? And let's talk about Trump for a second. You know, everybody else is. President Trump. First, they tried to impeach him, and they didn't have grounds. That didn't work. So then we tried something, and I would hope, Ambassador Eisen, that you didn't even agree with this. They try to take him off the ballot. They're scared of this guy. They try to take him off of the damn ballot illegally, incorrectly, and so the Supreme Court has to come in, liberals and conservatives, some real people from the left on that court, and say, man, this is just wrong. That didn't work. So what do you got left? You weaponize the judiciary. The only thing you can do. And what's teaching the lesson about? You know what not you guys, but you know what's being done? We're teaching, I really mean this, Americans to be afraid if they differ, if they speak out, especially if they happen, in this case, to have a conservative or different viewpoint. You know, talk about those people you speak with on the phone. I do it. I really do it, because my humble beginnings as a councilman and going all through, I've held every damn office you can hold. And you know what these people will tell you? Some of them are a little nervous about putting signs up. They're a little bit nervous about giving a campaign contribution because they're afraid they're going to go after them, because you know what they know. If they went after this man, they can go after you. Now, the right thing to do here is the judge should have recused himself. The right thing is not to have the trial in a town with a prosecutor who's made it his aim in life to go after him. It's wrong. And people are afraid they're going to go after your family, your friends, your businesses, your life. Politics, money, and teaching a lesson. And you know what? It's a tale of two prosecutors, and I'm running out of time and I want to ask a question. But this is a guy who wants to prosecute non-existent crimes, like this one. But damn it, he won't prosecute the violent crimes, and he downgrades them in the city of New York to misdemeanors. And he's causing people to get murdered and murdered and robbed and hurt. I'm only going to get one question in here, but I'm going to squeak it in. Commissioner Traynor, can you elaborate on why the FEC Commission did not move forward with an investigation? And I know we've talked about this, but I want to hear it again. The FEC, who should have been the ones to do it, they said, no, we're not going to do it because they were neutral and objective. Why didn't they do it?
The Commission did not move forward with an investigation because we were asked to abate that proceeding by the Department of Justice. The Department of Justice then took over a year to conduct a criminal investigation, and then when they sent the information that they had back to us after they had declined to prosecute anyone in the case, the statute of limitations had run when it came back to the
Real
commission.
quick, thank you. Ms. Foley, your testimony highlighted significant due process violations. Can you just detail that a little? 3 core due process precepts: notice, meaningful opportunity to defend, and proof of all relevant facts. We only have a few seconds, if you could.
Yeah, lack of adequate notice of the charges and the basis of the charges by obfuscating a primary element of the felony falsification offense, which required that there be another predicate offense that was intended to be committed. They obfuscated that till the very end, until the jury instructions. Once they identified that in the jury instructions, it became clear that there was a second predicate that was required that Trump never had an opportunity to respond to whatsoever, much less have notice of.
Chairman.
You know what, I yield back, and Ambassador Eisen, damn it, I wish I could have gotten to you.
The gentleman yields. The gentleman yields back. We have
Chairman, I have a unanimous consent.
unanimous consent request from the ranking member.
Mr. Chairman, I ask unanimous consent introduced for the record an April 12, 2023 article from PolitiFact that states, quote, "We reviewed Bragg's campaign record and found that although he often cited his prior prosecutorial experience with respect to Trump and said he was equipped to inherit the DA's office investigation, he made no promises about any case. He said that although he had access to some publicly available information about Trump's activities, he didn't have all the information and wanted to be fair," close quote.
Without objection. Let me just real quickly say, we have 15 minutes left, Ms. Scanlon and 2 on our side. I have to jump out for a meeting, but I wanted to thank each of you for being here. Mr. Eisen, I certainly did not work with you when you were trying to impeach the President of the United States. But let the record show, I have allowed you to hawk your book at the committee hearing and didn't object to that one bit. Ms. Foley, Commissioner Traynor, we do appreciate your being here and your testimony as well. Thank you for being here since 10 o'clock this morning. We appreciate that. I'm going to let the next governor of North Dakota chair the remainder of the hearing, and we'll go to Ms. Scanlon for 5 minutes.
Thank you, Mr. Chairman. And as the chairman acknowledged, we didn't start at 10. We started nearly an hour late, or just over an hour late, because he and his Republican colleagues had prioritized a meeting with Donald Trump over a committee hearing. And presumably they received their latest marching orders to weaponize congressional power against our criminal justice system, because that's what we're seeing here today. It's outrageous. Over and over again, this Congress, we've seen House Republicans set aside congressional work, the people's business, to do the former president's bidding, as he seeks to avoid justice and accountability for his numerous misdeeds. Their members, including the House Speaker, have spent hours injecting themselves into these state court proceedings and standing outside the Manhattan courthouse instead of working on legislative business to serve the American people. They don't seem to understand that they were elected to serve their constituents, not the disgraced, twice impeached, and now convicted leader of the party. So why are we here in today's hearing? Because 2 weeks ago, a jury of Donald Trump's peers, 12 American citizens, found him guilty of criminal conduct. Now, those jurors were selected by both the prosecution and Mr. Trump. Those jurors considered all of the evidence presented to them by the prosecution and by the former president, not just the evidence or, as is so often the case, the alternative facts that are selectively presented by social media, cable pundits, or political spin doctors, including some of those here today. Because unlike our political sphere, that's how our justice system works. The jurors performed their civic duty, they did their job, and when they applied the law to the evidence, they determined that the former US president was guilty of 34 felonies. Now, having a former president found guilty of criminal conduct is a sad day for our nation. But it's sadder still that the former president is using his allies here on the Hill to attack our courts and undermine the rule of law, and that members of Congress are debasing themselves and this institution to embrace his conspiracy theories and lies. Unfortunately, these attacks upon the very foundations of our government to prop up the former president have become the norm for their party. When Donald Trump couldn't bend journalists' coverage to his will, MAGA Republicans echoed his attacks on the free press. When American voters rejected Donald Trump's first re-election bid, MAGA Republicans helped him sow chaos, confusion, and conspiracy theories to drive his attempts to overturn that election. And now when a New York state jury trial has resulted in Donald Trump's first criminal conviction, MAGA Republicans are attacking the state's prosecutor, the judge, the witnesses, and the jury. And as several other criminal cases against the former president head to trial, House Republicans are introducing legislation to fire prosecutors, to defund the Department of Justice, and to deny states the authority to prosecute crimes committed in their jurisdictions. Disturbingly, we now see this pattern of behavior anytime anyone tries to hold the former president accountable for his words or actions. House Republicans have been trying to interfere in the New York State case since its inception, even though such interference violates both our constitutional separation of powers and our federalist system. Every step of the way, House Republicans have attempted to insert the federal government into a purely state and local matter without any credible pretense of jurisdiction, and they're continuing their outrageous, unproven accusations against the Manhattan District Attorney's Office with this hearing. Republicans say that they're the party of law and order until their chosen candidate for president is convicted, and they claim to support states' rights until a state court rules in a way that they dislike. The truth is that America is built upon the idea that no one is above the law, including former presidents and their allies, and these shameless attempts to subvert our most fundamental American institutions threaten the rule of law that our country is built upon. So, Ambassador Eisen, why is it dangerous for members of Congress to try and influence the outcome and attack the legitimacy of a criminal court and a free and fair trial, and how does it threaten judicial independence?
The genius of the American project lies in our federalism, our checks and balances, the laws, starting with the Constitution, that reinforce staying in your lane. When I worked in the White House, it was the first rule: stay in your lane, and that's the rule for a functioning democracy as well. There's no place, just like there was no place for Donald Trump to tell Brad Raffensperger in January 2021, just, quote, find 11,780 votes. There's no place for Congress to be meddling in these state prosecutions.
Thank you, and I see my time's expired, although there has been a fairly loose gavel. But I'd ask...
Mr. Armstrong is even more generous than Chairman Jordan.
I would just ask unanimous consent to introduce an article from this morning's Politico entitled "Trump's Private Demand to Johnson Help Overturn My Conviction." Thank you. I yield back.
Gentleman from South Carolina is recognized.
Thank you, Mr. Chairman. Ms. Foley, did Alvin Bragg's indictment actually articulate a provable felony offense?
Did the indictment?
Mm-hmm. Yes,
No.
ma'am.
I mean, the indictment was about as generic as you could get. I mean, one of the primary elements is the intent to commit another crime. The indictment said nothing about that. And he provided a statement of facts that accompanied the indictment. That also said nothing about what that other crime was.
Why do you suppose that was, that it omitted that?
I think to the extent that you want to convict someone, you hide the ball, you obfuscate, and that keeps the defense counsel on their toes. They don't know what evidence to put forward to the jury. It's an ever-moving target. It makes it very difficult to defend if you're a defense counsel.
And how does that impact the jury instructions in the end? You talked about that, but I want you to discuss that again.
Yeah, well, you don't know till the end, if you don't know till the end, what exactly the first predicate is. You don't know who to put on the stand. You don't know what evidence to put forward. The only reason he tried to bring forward Brad Smith, for example, the former FEC chair, was because Alvin Bragg kept hinting that maybe one of the bases for the first predicate was the FECA violation. And so he kind of knew that, so he tried to get a witness to say something about that, and he was denied. So it was just an exercise in futility for Trump to try to defend this case, because it wasn't clear exactly what he was being charged with.
Thank you for that. And just changing gears a little bit, who's Matthew Colangelo?
Well, he was, the number 3 guy in the Department of Justice?
Correct. And what is his current title? What does he do now?
He's on Alvin Bragg's prosecutorial team. I'm not sure exactly what his title
At a
is.
state DA.
Yeah, state DA, that's correct.
Is that unusual to see somebody go from, the number 3 position at the Department of Justice to a state district attorney?
You know, I know some other members of the committee have suggested, well, you know, you do it out of the goodness of your heart because you're a public servant and all that jazz. And I'm sure that's true, but at the same time, it's exceedingly unusual for that to happen, for you to take a downward movement in your career. And because of the unusual nature of it, it makes you go,
Yeah, I think it raises questions, and I think the American people see that. I think polling consistently shows that the American people believe that the prosecution of President Trump in Manhattan was more about politics than it was about some violation of the law. And of course, we've seen that, right? I mean, District Attorney Bragg campaigned on going after a certain individual, not some violation of the crime. It was identify the man and then go after the crime. And I think that's incredibly alarming just for the justice system broadly. Is it fair to say that as a former DOJ official that Mr. Colangelo would have high-level contacts within the Biden Department of Justice?
Oh, undoubtedly. And I hope if he does actually show up before the committee that there are a lot of vigorous questions about that.
If there was or continues to be some sort of coordination between the Department of Justice based on those contacts and the District Attorney's Office, what effect would that have on a case?
It would be a tremendous effect. I mean, it would be a huge advantage for someone from the Department of Justice to sort of implant themselves in a state prosecution, which involves state crimes, obviously, only, because it would benefit his former boss, the person for whom he worked. And, you know, again, it would just sort of re-emphasize the impression, the suspicion that this is a politically motivated prosecution.
I think that's why it's important, too. Let me, are you aware that members of Congress have the ability to remove cases from state court to federal court?
Yeah.
Judges, same thing. There's a bill that I've introduced called the No More Political Prosecutions Act, which would allow that to happen. Why might a president or former president want to remove the venue from a state district case to a federal jurisdiction?
Well, you know, the hallmark of federal judges as opposed to state judges is they're appointed for life with the advice and consent of the Senate, whereas state judges are generally elected. And so they're more political creatures by nature. They wear the robes of legislators to a certain extent because they do have to stand for election. So you hope to get the neutrality, you know, the political independence from a federal court.
In your experience, does the jury selection process, is that more robust at the federal level than it is at the state, generally speaking?
Yeah, absolutely. The voir dire is much more extensive. The judge controls that process much more in terms of making sure abuses don't take place. So yeah, I would assume that in general, the federal judicial process is much tighter and less loosey-goosey, I guess is the way I'd put it, than a state process.
Thank you, Ms. Foley. See, my time has expired, Mr. Chairman, soon to be governor of North Dakota, and with that, I yield.
The gentleman from Virginia is recognized? Or do you? No, gentleman from Texas is recognized.
Thank you, Mr. Chairman. When a Democrat gets convicted of a crime, it's called political retribution. When a Republican gets convicted of a crime, it's called justice. This is the justice system that the American people have seen and come to expect over the course of the past few years. Soviet-style show of trials to persecute political enemies. I keep hearing my colleagues on the left say, no one is above the law, and Trump is being treated like anyone else would be. But we're talking about Trump's conviction only. But is that true? In American justice system, we do find that we target, then look through the entire life of history to find a crime, any crime that can be used against them, and then contort the law to convict that target. That's what the Manhattan DA Alvin Bragg did. And how do we know this? That's what he campaigned to do. Do you know who else campaigned on that? Letitia James. And then they delivered on their promises. And the number 3 guy in the Department of Justice, Matthew Colangelo, even left a high-profile job, as you just articulated, ma'am, in the DOJ to work for a local DA's office with Alvin Bragg. That's weird. So from now until Election Day, Democrats will keep calling President Trump a convicted felon, and that's because Alvin Bragg delivered for his team. Now, we're talking about a man in President Trump who is the most investigated person in our country's history. And the only thing that Alvin Bragg could bring up was a zombie crime that no one else wanted to prosecute. And speaking of that zombie crime, I and the American people are still waiting to hear what the underlying crime actually is, and no one can tell us that. The left keeps touting themselves as the gatekeepers of democracy and that they are the adults in the room and can impartially administer justice. I know this doesn't have to do with the Manhattan DA's office. I understand that. But I'd like to highlight a few political prisoners of the Justice Department. While Joe Biden and his team are scaring people into thinking that Donald Trump will put people in jail, Joe Biden is already putting political enemies in prison that we know of. Let's start with the 74-year-old economist Peter Navarro, who served in the Trump administration. Do you know where he is currently? Peter Navarro is currently sitting in a jail cell in Miami for not complying with a subpoena from the Democrat-led January 6th committee. How about Steve Bannon? He has to surrender himself by July the 1st or he will be arrested. His crime, not complying with the subpoena from a Democrat-led January 6th committee. Now let's talk about Eric Holder. Oh, that's right. He never went to prison. The DOJ decided not to prosecute him after he ignored a congressional subpoena during the investigation into the Fast and Furious scandal. Does anyone find that hypocritical? Because Lord knows I do. And what about the Attorney General Merrick Garland? He was just held in contempt by the House yesterday. And how many Democrats are going to jump on the side of Lady Justice now? I have a prediction. Nobody. In our 250-year history, we haven't had this problem until Joe Biden was sworn in office, but now we're witnessing the Democrat Party persecuting and jailing their political opponents, including the former president, our party's nominee, and likely the 47th president of these United States of America. Biden is right when he says democracy is on the ballot this November. The only problem is that Joe Biden is on the wrong side of history. I hope and pray that Alvin Bragg and Colangelo will show up to testify before this committee next month. We've asked them, and we shall see. Because the American people deserve oversight, we deserve better, and we deserve accountability. I know it's been a long day for you all, but thank you so much for being here. I really appreciate it, and I yield back the rest of my time. Thank you.
The gentleman from Virginia is recognized.
Thank you, Chairman. On May 30th, Donald Trump was found guilty after years of lawfare by the radical left. And this is the result of a justice system that has been abused and used against the former president for quite some time. Mrs. Foley, can you explain for us what the primary jurisdiction doctrine is?
Primary jurisdiction doctrine is that federal offenses are generally adjudicated in federal court.
The purpose of this doctrine is to allow an agency of competent jurisdiction to review the facts to determine if there was, in fact, a violation of the laws that the federal agency administers, correct?
Correct.
The theory underlying the doctrine is that Congress has designated these federal agencies to adjudicate such questions because the agencies have a special competence and expertise over factual and legal questions within its designated mandate, correct?
Correct.
Was the primary jurisdiction doctrine implicated in the Manhattan criminal case against President Trump?
I'm going to assume so, and I would defer to Commissioner Traynor on this, but FICA is not my area of law, but what I will say is, having looked at the FICA statute in preparation for this testimony, I'm shocked that there's been no preemption argument here.
Commissioner Traynor?
I would agree with Professor Foley on that. I mean, the whole purpose of my testimony was to highlight the fact that the jurisdiction that was asserted here is jurisdiction that belongs to the Federal Election Commission that could ultimately then refer it to the Department of Justice.
Do you believe the Justice Department should have intervened to protect both the FEC's jurisdiction and its own?
Without question.
And did the Justice Department intervene?
They did not. They only intervened in the Federal Election Commission's investigations.
So in other words, the Biden Justice Department allowed the Manhattan DA's office to usurp both the Justice Department and the FEC's jurisdiction, correct?
Absolutely.
And tell us, why is that problematic?
Well, it's problematic because it sets up a system. Well, first and foremost, it allowed the judge to get the law wrong in this particular case and issue a jury charge that had to do with willful contributions as opposed to knowing and willful contributions, which is what the law requires to be proven. But in a larger picture, it sets up a standard where you can have 50 different states trying federal election crimes under various standards.
Judge Merchan neither stayed nor dismissed the case on primary jurisdiction grounds, did he?
He did not.
In fact, he, along with the 12 residents of New York County, decided that issue, correct?
They did.
And do you believe that the Trump conviction will be vacated on the primary jurisdiction grounds?
I think that that's definitely a possibility.
All right, thank you. I yield back.
Thank you. All right, I just want to kind of bookend this thing a little bit and be like, and we know this, the first federal prosecutor decided not to, decline prosecution. Commissioner Traynor told that. The first DA, Manhattan DA, didn't prosecute, and then Alvin Bragg actually, campaigned on prosecuting it. And at the core, this is a false business record entries were used to cover up a conspiracy to promote an election by unlawful means. So the filing of false records is a misdemeanor, 2-year statute of limitations. The New York conspiracy is a misdemeanor, 2-year statute of limitations. By combining those two, you get to where you can actually create the felony with statute of limitations. Outside of anything else and talking about political, not political, there's an unbelievably aggressive use of prosecutorial discretion. So the charged offense is the falsifying business records. The predicate offense is the New York concealing a conspiracy to interfere. But here's where my question comes in, and this is, I've actually read all the jury selections. The unlawful means is where we get this grab bag, right, Mrs. Foley?
Yes, that's where we get 3 possibilities instructed by
And it's in basic pick. But I went through the jury instructions, and here's my question. What elements of any of those predicate crimes are unlawful means? Conspiracy in and of itself is, so if you charge a second offense driving under the influence, usually the sentence for a second offense is different than a first offense. In order to get to the second offense, you have to prove the first offense beyond a reasonable doubt.
Right.
Now, in those types of cases, it's a certified record of a court judgment. You just put it in the record. I've objected to just about everything that's ever been put into court when I was doing this. It's impossible to object to that. So when we're talking about these unlawful offenses and these 3 picture things and dealing with the New York misdemeanor statute, that when you combine with the other misdemeanor statute, you end up getting to this felony and past the 2-year statute of limitations. But was the jury required to prove any of those underlying elements beyond a reasonable doubt to any of those crimes? Because I'm talking about the Fifth Amendment and the due process part of that.
No, and in fact, based on the instructions, we don't even know which of those possible 3 areas of law the jury decided because they didn't have to be unanimous. But it's really more than 3 laws, too, by the way, because the tax laws that he instructed the jury on could include local, state, and federal tax laws. And by the way, the mention of local or federal tax laws had never been made at all before. At most, right, the prosecution had mentioned the possibility of state tax laws as being the first predicate, not the second.
Yeah, and I'm actually into the 3rd layer of this because unlawful means, I'm just thinking of, I've never defended a case in New York. I've just never practiced in New York, but I have defended cases in state court and I've defended cases in federal court. And I'm thinking about arguing against a case when I made my living on if there were 7 elements of a crime, winning one of them. I don't need to win all 7. I got to get proof beyond a reasonable doubt on one of the 7 elements. And they're not laid out anywhere in this whole process, are they?
No, that's the problem. You don't know how the jury got to where they got at the end. In fact, you didn't even know how they could get there until they were instructed. And then once they were instructed, because they could, kind of pick and choose which of the unlawful means they wanted to base the New York election law violation on, you have absolutely no idea why President Trump was guilty of a felony based upon theories of 2 different misdemeanors.
So, I'm glad you said that because I was busy and doing all of these things, and I tend to not listen to the cable news rhetoric and on all of these different things because I've actually been in there, and I think they get it wrong a lot. But I get through it and I read it, and I'm like just thinking, how do you possibly do this? And that's where I'm frustrated, and I'm frustrated with the rhetoric like today too, because like I've been criminal of the administration of justice since 2003 when I got sworn into the North Dakota bar. I mean, I've introduced bills on exculpatory evidence, recording interrogations, crack parody in sentencing, acquitted conduct, all of these things, oftentimes working with the other side of the aisle. But the nearest I can think of, and I agree with you, and I appreciate you saying it earlier, the jury's only as good as the instructions they get. I do not criticize the jury. I get a little frustrated. I mean, political demographics and all of that, I mean, I've dealt with that. I don't criticize the jury. But nearest I can figure out, anybody who criticizes Judge Merchant or Judge Bragg is like, DA Bragg is like causing our criminal justice system to come crumbling down, and democracy at itself is gonna fail. But Judge Cannon, Judge Alito, and Judge Thomas, completely on limits. You can do that whenever you want. So I think what it really means is if you don't agree with me, you're a danger to democracy. If you agree with me, you're perfectly acceptable. And with that, I yield back. All right. This concludes today's hearing. We thank our witnesses for appearing before the committee today. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or any additional materials for the record. Without objection, the hearing is adjourned.
All right, everybody, thank you for joining me today. It was an hour late. I'm not going to hold it against them. I didn't know that it was for President Trump. Of course, we're okay with that here. Just kind of, all right. Mugs at DaveTheLawyerStore.com. Great Father's Day gifts, by the way, chat. I'm not going to push it too hard on you. I like them, but I love caffeine. That's my #1 drug of choice. So with that, I guess we'll see each other tomorrow maybe, or, check out, if you haven't already, subscribe for more. I say knowledge is power. Subscribe for more. Check out my stream or what, my YouTube page. I just put out a video about Kennedy and the judicial nominations, him judging, him grilling the judges, judging the judges. Probably gonna do a few more of those, maybe Hawley, Mike Lee next. Check it out. Thank you, everybody. Matt, everybody else who's still here. Appreciate it. Thank you. Vorpalali. I appreciate everybody. Jacob, Outlaw, thank you. All right. And with that, I bid you adieu.